meeting of the Charleston County Board of Zoning and Appeals, also known as the BZA. The board members that will hear your case tonight, to my right, Mr. Nelson, Mr. Jordan, and Mr. Marchant. To my left, Mr. Borkin and Ms. Switzer Smalls, and I am William Ray, the chairperson. Staff members present tonight are Mr. Spencer Antos, Ms. Sally Brooks, Mr. Joshua Downey, Ms. Jennifer Stiles, and Ms. Jenny Working. Mr. Kevin Hugie to my right here is the attorney for the BZA. Because the hearing tonight is a public fact-finding meeting, we are in compliance with the Freedom of Information and Act and South Carolina Code 6-29-720. 15 days prior to the hearing, an announcement was printed in the Post and Courier. A sign was posted on or near the designated property, and a notice was mailed to the applicant or the applicant's representative, to the property owners within 300 feet of the property, and to parties of interest. Persons, organizations, and news media has also requested declaration of our meeting and also have been notified. Board members, meeting notes for October 3rd, 2020 for the public hearing were mailed to you, emailed to you. Are there any changes? If not, can I get a motion to approve and a second?
Move to approve.
Second.
All right, I have a motion to approve and second. All those in favor indicate by saying aye.
Aye.
Any opposed?
Abstain, just.
Yes, sir, you were not here. Good. It carries. Very good. Our case ruling from this and any BZA meeting is available to the public for review and inspection during normal business hours at the Charleston County Zoning and Planning Department. The Board of Zoning Appeals is a quasi-judicial body and has final decision-making authority on the following: appeals of a zoning-related administrative decision. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that there is an error in the order, the requirement, decision, or determination made by the administrative official in the administration or the enforcement of any zoning-related regulations. A 2/3 vote of the quorum is present required to overturn the decision of the planning director in an appeal. We also have special exceptions. A special exception is an exception issued by the BZA authorizing a particular use in a specified location within the zoning district, upon demonstrating that such a use complies with all conditions and standards specified by the Zoning and Land Development Regulation, also known as ZELDAR. The BZA must find the special exception meet all 6 of the criteria in the ordinance in order to grant a special exception. A simple majority is required to grant a special exception. And then finally, we have a variance. A variance is a relaxation of the BZA's regulation of the ordinance, where such an action is not contrary to the public interest and where, owing to the conditions particular to the property and not the result of the actions or the situation of the applicant, a literal enforcement of the code will result in an unnecessary and undue hardship, and such a variance is consistent with section 6-29-620, 6-29-800 of the Code of South Carolina, Title 6, Chapter 29. The BZA must find that the variance meets all 7 of the approval criteria in the ordinance in order to grant a variance. A 2/3 vote of the quorum present is required to grant a variance. The purpose of our meeting tonight is for interested parties to hear or to be heard in order to assist this board in gathering evidence that's pertinent to each case. If a board member of the BZA finds a need for further information to clarify a case, the board member has the authority to subpoena witnesses. It must be understood that the rules in your neighborhood or subdivision are binding, and that we can take no action to negate their jurisdiction over your property. In addition to your testimony, the board has been presented written information submitted by the staff or the applicant's agent. This information is now presented to this body and is entered into the permanent record of this body. It is assumed that it is complete, true, and accurate. In addition, we have been presented data assembled by staff for the purpose of clarifying the location and the application effects on surrounding properties. Our board is empowered to approve with conditions, or to deny special exception or variance requests. We also are authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of this public hearing tonight. It will be mailed, certified mail to the applicant and general mail to the neighbors and the community of interest. If an applicant's request is approved, the applicant should contact the Charleston County Board of Zoning and Appeals staff to discuss the next steps in the process. Variances and special exceptions granted tonight are valid for 12 months after this meeting. A 1-year extension may be granted only if construction or the development has commenced or have been pursued. However, if an applicant's request is denied and the applicant wishes to appeal the decision of this board concerning the case, an appeal must be addressed to circuit court. South Carolina Code 6-29-820 states that the appeal must be filed by the applicant within 30 days after the decision of this board. A failure to file an appeal within that time limit prevents and deprives the court of this jurisdiction to hear the matter. Because this is a quasi-judicial body, everything in this meeting must be complete, true, and accurate. All the information provided to the BZA is considered evidence. This board may certify contempt of circuit court if false testimony and statements are made either in writing or orally. Each person who wishes to speak to this board tonight will be sworn in by the BZA secretary before they can provide testimony or evidence. In order to expedite this procedure, all those individuals who wish to speak to this body, I'd ask at this time if you would please stand and Ms. Working will administer the oath.
Okay, please stand and raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do. Thank you.
Thank you, Ms. Working. I will now call each case by case number. Staff will present facts that are pertinent to each case, limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and the current address for the record before presenting testimony pertinent to the case, limited to 5 minutes. I would then ask for those speaking either in support or opposition of the case. They will also follow the same procedure in identifying themselves. And they are limited to 2 minutes each. And the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application, stating specific findings of facts and conclusion of law. Tonight, we will hear 5 cases opening to the public. Ms. Working, the first case tonight we'd like to have is case BZA 0722-00594.
Okay.
Thank you.
The applicant and property owner, Joyce Capers, represented by Capers G. Barr III of Barr, Unger, and McIntosh LLC, is requesting a variance for retroactive grand tree removal and to eliminate or substantially reduce the mitigation required pursuant to the Charleston County Zoning and Land Development Regulations Ordinance for a grand tree that was removed in violation of the ordinance at 2182 Gulf Drive, which is TMS number 57705000004 in the east area of the county. The subject property and properties to the south are located in the Mount Pleasant Overlay Sweetgrass Basket Stand Special Consideration Area, Residential Area Zoning District. Adjacent properties to the north, east, and west are located in the town of Mount Pleasant's jurisdiction. The 12,600 square feet or 0.289 acre subject property is vacant. The 36-inch diameter breast height or DBH grand live oak tree was removed by the property owner without a variance or permit on April 11th, 2022. The applicant's letter of intent explains the variance request and quotes, This is an application for a variance to approve the removal of a grand tree from the property of Joyce Capers at 2182 Gulf Drive in Mount Pleasant, the subject property. The application seeks retroactive variance approval. Alternatively, the application seeks an order from this board to eliminate or to substantially reduce the mitigation ordered by the county enforcement officer. The tree was removed by Ms. Capers following which she was cited by Charleston County enforcement officials for violation of the county tree ordinance. She was guilty and has paid a fine. This application seeks the retroactive approval of a variance to remove the tree and alternatively appeals for a variance as well of the mitigation sanctions imposed upon Ms. Capers by the county code enforcement officials, end quote. So now I'm going to go through a timeline of the violation. So on March 29th, 2022, the Charleston County Zoning and Planning Department Code Enforcement staff received an anonymous complaint regarding the property owner's plans to cut down a grand tree. On March 31st, 2022, the county's arborist investigation revealed a healthy 36-inch DBH grand live oak tree on the property. The tree was marked with survey tape, and the county zoning ordinance was noted with the tree size. On April 1st, 2022, a code enforcement officer informed the property owner, Joyce Capers, that the tree is a grand tree that is protected and that mitigation would be required if the tree was cut down without permits. On April 11th, 2022, a code enforcement officer informed the property owner, did I do this one? I think I did that one. April 11th, 2022, the tree was cut down. A summons was issued to the landscaper, Kevin Baxter, and to Fred Capers, who claimed to be the property owner. On May 24th, 2022, the case went to court, and the property owner was found guilty and fined $250. On July 15th, 2022, the variance application was filed with a $250 application fee. And then on August 22nd and October 17th of this year, we conducted site visits on the subject property and posted the BZA public hearing notice signs. So regarding an explanation of the general process, when a grand tree has been removed in violation of the ordinance, a magistrate's court summons is issued to the defendant, and trees shall be replaced in accordance with a replacement schedule approved by the planning director. The minimum combined caliper of replacement trees shall be equal to or greater than 3 times the caliper of the grand tree removed. The court presides over the fines associated with the guilty summons judgment, and the planning director imposes tree removal mitigation. Only claims valued at $7,500 or less can be brought in magistrate's court, and the value of this amount of mitigation trees is likely to exceed the $75,000. Therefore, if the defendant is found guilty and disagrees with amount of tree mitigation imposed by the planning director, they may file a variance with the BZA for relief. So we're going to provide the mitigation calculation, and this is per Chapter 11, Violations, Penalties, and Enforcement, Article 11.6, Tree Protection and Preservation Violations, Section 11.6.1, Trees Removed Without Permits, and then B, Grand Trees, which states, and quote, where grand trees have been removed in violation of this ordinance or removal is necessitated at any time due to acts of negligence, trees shall be replaced in accordance with a replacement schedule approved by the planning director. The replacement schedule shall establish the number, species, caliper, and location of the replacement trees, and at a minimum shall require A, that the combined caliper of replacement trees is equal to or greater than 3 times the caliper of the grand tree removed, and B, individual replacements of trees are of the largest transplantable caliper available or equal to the loss of DBH inches, end quote. So for a 36-inch diameter times 3, that would equal 108 inches. Total of 108 inches replacement on site, or the value to the tree fund, or a combination of both. The minimum 2.5-inch caliper replacement on site, that would require 43 trees to be planted, which wouldn't be realistic for the size of this site. The value of 2.5-inch caliper trees planted is approximately $250 to $500 per tree. Therefore, the value of 43 trees to the tree fund would be approximately $10,750 to $21,500. And per section 926D tree replacement, the applicant shall provide a minimum of 2 quotes. However, no quotes have been provided for this case. And then, let's see, and I'd be happy to read over that Zeldar section later if you need me to, but it is in your packets and on the slides as well. These are all this is just the overlay map. Zoomed in aerial photo, zoomed out aerial photo. And then we have the photographs of the site. This is some photographs of the tree that was taken on March 31st, 2022. Again, on March 31st, 2022. These photographs were taken on August 22nd, 2022. This is the site plan provided by the applicant and the plat. So we have received 1 letter of opposition, and that is in your packet. Regarding section 3.10.6 approval criteria, staff found that the application may meet 1 and 2, may not meet 4 and 7, and does not meet 3, 5, and 6. I'll briefly go through 3, 5, and 6 now. So staff's response to criterion 3, the application of the ordinance to 2182 Gulf Drive does not effectively prohibit or unreasonably restrict the utilization of the property. Staff's response to criterion 5, the reason for this variance request is based on financial hardships of the property owner. And staff's response to criterion 6, the need for the variance is the result of the applicant's own actions. The applicant property owner was aware of the tree preservation ordinance and elected to proceed in violation of the ordinance by removing the 36-inch DBH grand live oak tree without county approval. Staff recommends that the board make a motion to deny the retroactive grand tree removal request and to deny the applicant's request to eliminate or to substantially reduce the required mitigation, because the application does not meet criterion 3, 5, and 6. If the BZA makes this motion and the motion is approved, the property owner will be required to comply with the zoning ordinance. Article 11.6, tree protection and preservation violations, section 11.61, trees removed without permits, be grand trees, which was the mitigation that I presented earlier. And I've added that to this slide that went through already. The Board of Zoning Appeals action. The BZA may approve with conditions, or deny the case based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the variance application for retroactive grand tree removal and to approve reduced mitigation, staff recommends the following conditions. Condition number 1, all remaining grand trees on the property shall be preserved pursuant to the Charleston County Zoning and Land Development Regulations Ordinance, Article 9.2, Tree Protection and Preservation, Section 924, Required Tree Protection. Tree protection barricades shall be installed and inspected by the Charleston County Arborist prior to removing the remaining portion of the tree and stump. The tree stump shall be removed with as little soil disturbance as possible using a stump grinder. 2, the applicant shall mitigate the removal of the 36-inch DBH live oak grand tree by either A, submitting a mitigation plan for review and approval, indicating the installation of canopy trees no smaller than 2½ inches in caliper and at least 12 feet in height, equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 926 of the Charleston County Zoning and Land Development Regulations, or C, a combination of A and B. And that would be, condition number 2 would be a reduced mitigation from the mitigation that's required in Chapter 11, which is our violation chapter. Let's see what else I got. That's all I have. You have questions?
Any questions, Ms.? Go ahead.
Ms. Working, just a couple. The first one I've got is, does the 1,600 square foot buildable area apply to that lot for a residential structure?
Do you mean, is it 16 without the tree, or?
Well, no, what I'm saying, could they put a 1,600 square, do they have a 1,600 square foot buildable area on the property if the tree had remained?
I don't know. We didn't calculate that, so.
But is that not a requirement for residential lots in Charleston County, or would this lot be exempt from that?
It's not exempt from that.
Okay.
But we don't have enough information to determine that, the tree canopy or anything like that. Like, this plan doesn't even show the other grand trees on the site. Like, we don't have a survey that shows that.
Well, so that was kind of where I was getting to. I understand part of the argument that the applicant's making is that they would have been entitled to a variance potentially. They could have met all the criteria. If we don't know if they do or don't have the 1,600 square feet, that puts this board in a tough decision, because if they, in fact, don't have that 1,600 foot buildable area because of the tree, then we might very well have granted the variance due to an unreasonable restriction on the property. And I don't know, I can't speak for the rest of the board, but I feel like we might not have enough information to go forward, and I'll leave that to the chairman. Thank you.
Anyone else? Go ahead.
Can't get this mic to work. Ms. Working, I have a follow-up question somewhat related, and you may have the same answer because of the limited site plan that's provided, but a similar thought was going through my head in terms of, is this site if the tree were still there, would we be able to place a dwelling unit on the site? This diagram probably does not adequately represent the canopy and the root structure, and so, chances are that the buildable area would be decreased. Not knowing enough about the other grand trees on the site, and sort of to the previous question, do we have enough information where we could make a ruling that criteria 3 could be supported if we had more information? I guess that's one question. Okay. And the other is, can you talk a little bit more about criteria 5 and 6, especially the profitability piece? Because another thing I'm hung up on is, if the tree were there, the land value would be less, perhaps $10,000 to $20,000 less. And now that the tree's gone, it's worth more. And could we perhaps figure out a way to mitigate costs because of that? We have to wait to hear from the applicant. But any thoughts on that in particular, on number 5? And then can you address the site plan issue?
Yeah. So what we are concerned about is, people trying to use this board as asking for relief when, in fact, this person was told not to cut the tree. They could have been to this board already. You may have not granted a variance. We don't know that. And again, like you said, we don't have enough information. We would need a better site plan if they were trying to go for that. But as far as criteria 5, what I meant by that is they are just asking for complete relief. They didn't provide a number of what they would be willing to pay. They didn't get the 2 quotes. So they either want to eliminate, like not have any mitigation, which again, had you guys approved it, you might have approved it with mitigation anyways. We don't know that.
Go ahead, Mr. Boykin.
And that brings us right back to where we started. If there was an existing buildable area that we would know from a tree survey and or a site plan, then I would be very much inclined not to grant any relief because they didn't need the variance and they were told not to cut the tree and then they did it. I don't see why anybody on this board would support any reduction in that. But on the other hand, if they had a legitimate hardship and it was an unreasonable restriction, they most likely would have gotten the variance. And I think that information is critical for this board to resolve this one way or the other. And I would even go to the point of moving to defer or table this matter until the applicant can furnish that information, if that's something the board could do, or if the applicant would like to.
So, you know, with that being said, thank you. I was going to go to that anyway. Does anyone have a question otherwise for Ms. Working? Because otherwise, I guess we need to hear from the applicant.
To address one of those issues.
As far as the site plan is concerned, it would be good to have a survey from a licensed surveyor that can look if the stump is still on the site, verify the actual location, because this is just more of a diagram that appears than an actual survey.
Go ahead, Mr.
Right.
Nelson.
This may be a sidebar question now, but in terms of the tree fund, the county doesn't set any price for monies paid into the tree fund, do they? I think you mentioned there's a quote. They have to
Right.
provide quotes for the
Do
trees.
you want to go? Yeah.
Yeah, sure.
The nursery.
Yeah, it's outlined in the ordinance. It's based on the current market value, and because that can fluctuate, we don't assign a set price to it. And the applicant would provide 2 quotes and present them to the planning director, and then the planning director would decide based on the quotes what that value would end up being. But we just wanted to give you sort of an approximation as an idea of like what that could be.
And if they would have asked for the variance and provided the necessary documentation at that time, most likely the mitigation required would have just been 4 to 36-inch tree, not for 36 inches times 3.
That's correct. Yeah, that's only for violations,
Okay, that's all I had.
to try to prevent people from doing this.
Right.
Where you all would only probably do the inch per inch, if anything, because there are times in residential you may not require mitigation. It just depends.
Okay.
Or on a smaller lot like this, you may just require mitigation to the tree fund.
Okay, gentlemen and ladies, I think in pursuit of time, I think I'd like to hear from the applicant. So at this time, is the applicant present? Okay, please come forward, state your name and address for the record, and please tell us why we should approve your application.
Good afternoon, Mr. Chairman, members of the board and council. I typically, when I stand up, I say how long-winded I am, but I know you're not going to let me be long-winded, so let me get down to the chase. I'm privileged to represent my friend Joyce Capers. She is sitting next to me with her son Freddie. Joyce is 78 years old. She's retired. Well, she's not retired. She works as a part-time elder care assistant, and I know Joyce because she cared for my elderly parents when they died and before they died in 2003 and 2006. And just like Joyce, I would prefer not to be here asking you for this after the fact, but we're here. I can't give you a good explanation for why we're here. I wish I could. We wish we weren't. Joyce is sorry for what she did, but that doesn't really change anything. Central to this issue is, I think, the conversation I just heard, and Ms. Working, tell me how to work this. Do I do the right tab? There you go.
And you can
I think central to the conversation is this sketch, and it's not. It's admittedly not done by a surveyor, and having heard the dialogue prior to my standing up, we certainly would not oppose a deferral to study this more after I hear what your questions are, and perhaps that should be better developed. But that having been said, and Mr. Boykin, you were the one who posed the question. I think you were the first one. In all honesty, I did some and I might say I sketched that. I mean, but I did it from the photographs. I think it's pretty close. The buildable envelope is the central area, which is 60 by 90, and that's 5,400 square feet. So I figured if the existence of the tree reduced the buildable envelope by about 45%, that left about 2,900 feet usable within. Now, I'm not helping myself by giving you that answer. I understand. I don't want to waste your time either. So that's why I say we're willing to defer this for that purpose. The reason for asking you to consider a variance after the fact is quite simple, because I think if Joyce had come here when she should have and made this application to you, we would have had this conversation before. I think she meets the criteria because, as you know, the hardship standard is not an impossible hardship. In other words, it need only be a reasonable, an unreasonable hardship. And so that the bottom line of the hardship argument is simply that if you accept my Kentucky windage calculation and the presence of that tree reduces the buildable envelope by 45%, that means that the buildable area within this 12,000 square foot property is reduced to 2,900 square feet, which is only 23% of the whole. I realize that doesn't prevent a house from being built, but I suggest to you that presents an unreasonable hardship, an unreasonable restriction on the use of the property. So that's the central argument. So as I say, that's the hardship we present. Had we come to you and asked you for a variance, we think we would have met all 7, 9, or however many there are of the criteria. And I'll be glad to address them all. I have in my memorandum. I don't know whether you have the chance to read those ahead of time, the memorandum, or whether you're just seeing it now for the first time. So it's probably more than could be read in the few minutes that we have here before you. So to tick off the elements, the extraordinary circumstances, if you look at an aerial of the all right, Jenny, you might have to help me here now. Well, there it is. Well, that's not going to help you. If you look at the aerial on the left, do you have it on a pad in front of you?
So we can see everything that you see right here with monitors.
This doesn't give you a really good picture of it, but as you saw from the map, this is a finger of the county that sticks into the town of Mount Pleasant, and those Mount Pleasant properties to the north of this property are all developed, and they were all the trees virtually were cut off of those. And so if you look at those, if you look at the surrounding, is that my time or is that? That's time. All right. If you look at the surrounding properties.
So that is your time.
Oh, it is my time.
That was your time, unless we could have a board member that would allow you to have a little bit more time to explain. Unless you want to ask a question.
I'll be happy to ask a question.
Absolutely, yeah.
Mr. Barr, we certainly up here don't want to have a miscarriage of justice, nor do we want to condone a bad act. I think at a minimum, had your client come up here and ask for the variance, they would have had at least a survey of the property and a tree survey and a site plan to show that there would or would not be a 1,600 square foot buildable area. I think we'd be remiss in our duties as board members to make a decision on a case when that evidence is obtainable. And as long as that stump is still there, estimations could be done with the canopy. I would be reluctant as a board member to vote one way or the other because I feel like I'm blind. And I don't think I'd be doing your client a good service without having that information before me. So my question to you is, would you be willing to defer this matter to get those documents and then reconvene where we would have that information?
1 minute to just.
Yes, sir, please.
stated at the outset, if we can provide you with more information, we would. And again, the reason that I couch this as an approval after the fact is simply to show that there is a submissible case here, more than a submissible case, that a variance should have been granted in the first place. And if the variance is granted in the first place, then the ultimate goal is to reduce this mitigation cost. I mean, and we heard from Ms. Working.
I would concur with you on that, but that's the question. That is the question.
Absolutely.
We don't know. I mean, I'd love to take your word. I'm sure
No.
you're making an honest assessment, but my problem is we do need the facts. And I think that in fairness to this board and to your clients, that's not an unreasonable request from us.
I think not either.
All right, thank you, sir.
Mr. Chairman.
Go ahead.
I have another issue with this case, Mr. Barr, and I hope you can address criteria number 5, because one of the part of that criteria says the fact that property may be utilized more profitably should a variance be granted may not be considered grounds for a variance. I think we could most likely conclude that if the tree were still there, the value of the land would be less because the buildable area would be less. Now that the tree is gone, the value of the land is greater because it gives the future owner flexibility in that land use. Perhaps even to the tune of $15,000, $20,000, $30,000, $40,000, $80,000, $100,000. That I don't know. And I think this board deserves to know the profitability increase because of this tree being gone before we can even think about whether mitigation needs to be fully exercised or whether some leniency needs to be exercised. Because the problem I have is not just the fact that you may or may not meet criteria 3. Now that profitability gain is in question, the mitigation may be a very small amount of the sale of the property, which certainly isn't hardship for the seller, and for the buyer, they have a better use of that land. And criteria 6 has clearly not been met. So help me with number 5, because, and that may need additional information from real estate appraisers, pre-tree cuddle and post-tree cuddle, did I say cut? Sorry, pre-tree removal and post-tree removal, because I'm not convinced that the profitability gain is not there. I think it's probably pretty great. So,
Thank you, Mr. Marchant. That's a great question. My reading of criteria 5 may not be the same as yours, and forgive me if it's not, and you're the decision maker since it's your ordinance. But I think criteria 5 relates to use variances. It reads, the BZA shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted. In other words,
Mr. Barr, yeah, I know, but I didn't mean to interrupt you. Well, I did mean to interrupt
Beg
you.
your pardon?
I did mean to interrupt you. I apologize. You were going to explain, but you had a moment to counsel with your clients.
Yes, sir.
Are you going to ask for a deferral or not?
Yes,
Because we're
yes.
going.
Yes, sir, we are. We are. I thought I made that clear, but I was trying to help Mr. Marchant with his question.
Okay. All right. So we have a request before us, board, that the applicant is requesting a deferral. So I need a motion to accept his deferral.
Second.
Okay. We have a motion to defer has been properly moved and second. Let's bring it to vote. All those in favor, please indicate by saying aye.
Aye.
Aye. Okay, it is unanimous. You got your deferral. So,
Are there any more questions that need answers?
well, I think you've heard all the questions.
Okay, all right.
And so you know what needs to happen. If you don't know what needs to happen, then you need to speak with Ms. Working to find out what you need to do prior to coming back for us. Ms. Working, how long can we give him a deferral for, typically? Depending on our caseload.
It's up to 90 days. But yeah, December is full, so it definitely wouldn't be. And I don't know, it's going to take a while to get a survey,
Mr. Downing?
I would think.
Okay. So you're looking at January, okay?
Maybe.
Yes, sir.
So
Maybe.
maybe. So work very diligently to get all those things in line so this board can have enough sufficient information to make a sound decision.
Thank you very
Otherwise,
much.
you see what you're facing, okay?
Very much.
All right, thank you.
Thank you.
Okay. Thank you, board. Next case that we have on the docket is case BZA 09-22-00612. and that will be completed by Mr. Joshua Downey. Let me say this one thing before you start. Audience, if you will, we do have monitors in front of us. You won't see us looking behind us. We can see everything that you see back here. So don't think that we're not interested. We do have monitors that we can see up front. Please excuse me, but go ahead, Mr. Downey. Thank you.
All right, so the applicant and property owner, Matthew J. Noel, represented by Ross Appel of McDougall, Clan, and Appel, is requesting a variance to allow an access disturbance within the required 35-foot OCRM critical line buffer to facilitate a crossing along the eastern property line at the historic impound berm at 1505 Garrens Bridge Road, TMS numbers 627000009 in the east area of Charleston County. The subject property and the adjacent properties to the south, southeast, and west are located in the rural residential RR zoning district. Adjacent properties to the north and east are located in the resource management jurisdiction, the resource management zoning jurisdiction. The applicant is currently in the site plan review process, ZSPR case 12-21-00678 for impoundment repair for the disturbance on a 73.4 acre subject property that contains 32.51 acres of highland and 16.85 acres of critical line area and 24.04 acres of marsh. The applicant's plan is to disturb approximately 5.5 acres, and the remaining 68 acres will be undisturbed. So that is the subject property. And then, as stated, it is in the RR zoning district, and the property to the north and east are in the resource management jurisdiction. That is an aerial view of the subject property and a zoomed in aerial view of the subject property. If you can see along, there looks like a tree line there. That's where the impoundment berm is. So staff did conduct a site visit on the 17th of October. That is pictures of the subject property, the OCRM critical line, the impoundment berm, Garrens Bridge Road. So staff believe that it may meet criteria 1. It meets criteria 2. It may not meet criteria 3. It may meet criteria 4. Staff believe it meets criteria 5. It meets criteria 6. And it may meet criteria 7. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 09-22-006-612, a variance to allow a access disturbance within the 35-foot OCRM critical line to facilitate a crossing along the eastern property line at the historic impound berm at 1505 Garrens Bridge Road, TMS number 627000009 in the east area of Charleston County, based on the BZA's fact finding, unless additional information is deemed necessary to make an informed decision. In the event that the board does decide to grant the approval, there are 4 criteria recommended by staff. Prior to the zoning permit's approval, the applicant shall complete the site plan review process. The applicant shall provide a proposed restoration landscape plan in compliance with ZLDR table 9.4, 43, 35-foot buffer type E, utilizing native plant species for staff review and approval for all disturbances on the OCRM buffer frontage within the expectation of the limited area proposed. as a crossing to the impoundment berm. The applicant shall consult a certified arborist to monitor all grand tree disturbance within the wetlands buffer area with 40 feet of the 35-foot wetland buffer boundary, and provide a report to the planning director every year for 3 years from the date that the permit is issued, and mitigation for the grand tree removals may be required. And the applicant shall remove all necessary uses for recreational vehicle campers and structures such as storage containers from the parcel until the principal use has been permitted. All accessory structures shall require permits. That is a picture of the site plan and a plat. Any questions?
Any questions for Mr. Downing? Mr. Nelson?
This may be a question for the applicant, but there's the berm wraps around and joins the uplands at two different locations roughly adjacent to the property line on the north and the south, right?
I believe so. I'm not sure exactly where the property line is, but that would be a better question for the applicant, but I do believe so.
Okay, and so you don't know, it appears as though a new berm was built underneath the OCRM and the Corps of Engineers permit that actually allowed them to begin manipulating the waters within this impoundment again. Is that correct?
I believe so, yes, sir.
Okay.
Anyone else? Thank you, sir.
Thank you.
Is the applicant present? Mr. Appel, please state your name and address, and please tell us why we should approve this application, sir.
Mr. Chairman, thank you very much. My name is Ross Appel. I'm here on behalf of Matthew J. Novelli. I'm at 2036 E Wall Street in Mount Pleasant. My client, Mr. Novelli, is here, seated right behind me. My client purchased the property back in March of 2021. This is a 73-acre parcel zoned rural residential, and there was a historic rice impoundment on the property, which had fallen into disrepair over many, many years. My client hired a team to obtain all necessary Army Corps of Engineer and DHEC OCRM permits for a substantial and costly restoration project. Those permits were obtained, they're in the record, and the work has been completed. And as you can see on the screen, I had my client take some of these photos over the weekend. You can see that there's a bald eagle on his property that's nested. There's various shorebirds in the impoundment. Things are looking great over in the impoundment. The work was performed professionally, and the wildlife is taken up residence. Unfortunately, my client was told by his consultants at the time that while he needed federal and state approval, he wasn't informed of the county's zoning regulations. So here we are. We're here to seek a variance request for an OCRM critical line incursion, but only with respect to the eastern impoundment crossing. The western impoundment crossing, I was able to convince the county staff was a legal non-conforming element of the property because, of course, that's the historical crossing. And so this other crossing, which again was part of the approvals from the federal and state regulators, is necessary to traverse the impoundment safely. So you can essentially drive from one end to the other without having to do that Austin Powers three-point turn. I don't know if you're familiar with that movie, but it's very difficult to navigate a vehicle for maintenance and other recreational uses if you're not able to go from one side to the other. So I'll go ahead and dive into the variance criteria. I know we're always short on time up here. Staff has agreed with us that we meet the second and fifth criteria, so I'll focus on the others. Extraordinary and exceptional circumstances. There are no other similar historic rice impoundments in the near vicinity of this property. To the extent there are some, they haven't been permitted by federal and state regulators and undergone substantial renovations like my clients. And so the existence of this element of the property is a unique and exceptional circumstance. Number three, the also important third criteria, because of these conditions, the application of the ZLDR would unreasonably restrict the utilization of the property. This goes to the whole safe accessibility of the impoundment that I just mentioned. If you're not able to have two crossings, you're going to have trouble actually using and maintaining the impoundment effectively. And my client, this is not a commercial development. This is his forever home site. He wants to maintain and preserve the quality of the land and of course the rice impoundment as well. And so in order to do that, he's going to need the means and the ability to access the impoundment safely for regular maintenance so it doesn't fall into disrepair like it did the first go round. Substantial detriment. The property is located in a rural portion of the county. The property is large and the impoundment will not be used in a manner that adversely impacts residents. This is not an Airbnb. This is not a hunt lodge or club. This is for my client and his family and his friends. The use will be very minimal and low impact. You purchase a piece of property like this to get away from everybody and to live a low-key kind of life, and that's the intent here. So we believe that obtaining this variance will not be of substantial detriment to neighbors. In terms of the criteria that the need for the variance cannot be the result of the applicant's own actions, the quality of the historic impoundment prior to my client's purchase was not of his making. He purchased the property and the impoundment was in disrepair. So the failure of there to be a crossing in good condition is not the result of my client's actions. And then finally, the comp plan consistency element, the seventh element of the variance test. This use is not only consistent with the county's and the comprehensive plan's rural preservation goals and policies, it's also consistent with the historic preservation goals that the county has expressed over the years. Its ecological goals expressed in the comprehensive plan. These impoundments, when they're functioning properly, serve as critical habitat for bird species and things of that nature. So there's a lot of positives behind this effort. And the last thing I'll say is we respectfully request that the board not approve the conditions proposed by staff. I wrote a letter that I believe was sent out to the board. Site plan review and the buffer requirements requested by staff are exempted for single-family residential developments. And so by imposing those conditions on this variance approval, we would be required to submit the requirements that we're exempted from the ZLDR. So we don't think we should have to comply with those requests. But as always, happy to answer questions that you may have, and thank you for your time and attention to this matter.
Thank you, Mr. Appel. Do we have anyone that have a question for Mr. Appel? Mr. Nelson?
Yeah, I'm just curious because I'm fascinated by these things. I've spent a lot of time permitting both impoundments, their construction and their removal. And so a couple of things. One, with this being salt marsh, and again, this is more my curiosity than anything else. Does the owner have King's Grant title to that marsh?
He does not.
Okay. And that's fine. I mean, the state's issued a permit. You have a license to do the work. So
Correct.
I don't particularly have an issue with that. I was just curious because it's a very high bar to try and clear. And I did figure this part out, but the permit that was obtained from both the Corps and OCRM allowed the construction of a new dike down the property line, correct? And that's the eastern side of the property.
That's correct.
Is the other dike still remaining that's on the adjacent person's property?
It is.
Okay, so there's like a little triangle left over.
I believe that's the case. Yes, sir.
Okay. And you answered this question, but the intent for the rest of the property is for it just to stay as is. There's no conservation easement or anything like that proposed for this property, is there?
No, the ultimate plan for the property is for my client to be able to build a home on the site for him and his family. And the issue with the variance and it's been red tagged. So that effort has been on hold until we could resolve all these different zoning issues. We started with a big list of issues. We've been able to work through a tremendous amount of them through working with our staff. And we're down to this is the only remaining zoning issue on the property. We're good on 50% of the impoundment crossings. We're looking to get that other 50%.
Which it is
this
interesting.
evening.
Without the variance, you could actually drive all the way around the impoundment and have to turn around and drive all the way back and not cross that buffer line boundary. Yeah.
Well, given the width of the variance, that's where that complication comes into effect.
I don't have any other questions.
Thank you, Mr. Marchant.
Mr. Chairman, thank you. Can you pull up the site plan, Mr. Appel?
Sure.
I think I understand the physical conditions here. I just want Go to the next one down. Yeah, it's hard to zoom in. Yeah. So
we're,
I mean, I see it, but for everybody else, see it.
it's right there.
That's all we're talking about is that area.
Correct.
The western one, you're okay with, even though it's hatched, right?
Correct.
Okay.
Originally, that was going to be included in this, but we were able to successfully convince the staff that that was a
Okay.
legal non-conforming element because that was the original impoundment crossing, and we were able to go and look at satellite imagery from a few years ago, and it really wasn't that long ago when that was functioning.
Cool. All right. Thanks.
No
Appreciate
problem.
it.
Anyone else? Okay. Well, thank you so very much.
It's always a pleasure.
All right. Do we have anyone else to speak in favor of this application? Do we have anyone else to, okay.
Matt Novelli, property owner. I'm here today to,
State your name and your address.
it's Matt Novelli, owner of 1505 Garens Bridge, the subject property, and hopeful today everything gets cleared so I can build my home. Tried to do everything I was able to do. I'm new to South Carolina. The consultants said that I was good to go with all the work, and that's why I'm here today. And yeah, to get the home built.
Okay. Let's see if anyone has a question for you. Anyone? Mr. Nelson?
Yeah, I'll ask a question. Did Folkland Management help design the impoundment, Travis Folk?
Yes, he was one of my consultants.
He's solid. That's a good choice.
Yeah, he's been, before the project started, he was my first consultant. He's followed the project through.
Good deal.
Mr. Marchant? You had a question? Okay. All right. No other questions at this time. Thank you so very much.
Thank you.
Does anyone else would like to speak in favor of this application? Tongue-tied here. Anyone else want to speak in favor of this application? Does anyone want to speak in opposition? Does anyone want to speak in opposition? Okay. Well, at this time, it's closed to the public. Board members. Do we have any questions of staff? No questions of staff. All right, then I guess, ladies and gentlemen of this board, I need a motion to either approve or deny this case.
I'll take this one.
Mr. Nelson?
All right, in the case of BZA 0922000612, I will make a motion that we approve the request. In doing so, I find that it meets all 7 of the criterion necessary to achieve the subvariance request, correct? All right, so criterion 1, there are extraordinary and exceptional conditions pertaining to this piece of property. It is pretty unique to find an intact impoundment that you can rehabilitate. Criterion 2, these conditions do not generally apply to other properties in the vicinity. Again, it is difficult to find intact impoundments that you can manage properly, so I applaud the owner for doing so. Criterion 3, because of these conditions, the application of the ordinance to this particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. This has been a high bar to clear in previous projects, but I think in this particular instance, the variance that's being requested is really specific to this berm and to management of this impoundment, so I believe that it does meet this criterion. Criterion 4, that the authorization of the variance will not be of substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by granting of the variance. Again, a well-managed impoundment is a benefit to the, particularly to the owner, but even to the community as well. Criterion 5, the BZA shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted in a zoning district. There are no other uses proposed that don't meet this particular criterion. Or criterion 6, the need for the variance is not the result of the applicant's own action. Again, after meeting both federal and state permitting requirements, I do believe that we meet this particular criterion, and criterion 7, that granting of the variance does not substantially conflict with the comprehensive plan or purposes of the ordinance. In granting this variance, I would move I'm compelled by the applicant's arguments that the special conditions should not be required since this is just for a single-family residential purpose. I would say that if there is an intent to develop the property even further, then at that point they would have to go through site plan review. Isn't that correct, staff?
So the applicant had not had any of this disturbance reviewed within the residential zoning approval process. And because it exceeds the 5,000 square feet, it's in site plan review. And so whether you have a residence or a commercial property, if you have waterfront development standards, you would be required to maintain that buffer. So our perspective is that that buffer, those kind of restorations would be required.
All right. Well, I guess maybe I should have asked that question before I started the motion, but I would say that special condition 1, prior to zoning permit approval, the applicant shall complete the site plan review process since the ground disturbing activities is greater than 5,000 feet. Criterion 2, I believe the applicant would have to comply either way with the landscape plan, or special condition 2. So the applicant shall provide a proposed restoration landscape plan in compliance with ZELDAR 9.4.4-3, the 35-foot buffer type E, utilizing native plant species for staff review and approval for all disturbed OCR and buffer frontage, with exception of the limited area proposed as a crossing to the impoundment berm. I'm not going to include criterion 3 and 4 at this time. That would be my motion.
Oh, hold on. So I want to make sure I'm clear on this. You're not including
Criterion 3 and 4.
criteria 3 and 4. Okay, and that's your motion. All right. Do I have a second with that? Or did you have a
I was
question?
going to ask for a discussion real quick before
We have to have a second for discussion.
Yes.
Second.
We have a second. Now,
We can change the motion if necessary.
No, I'm good with your motion. I just had a question I wanted to bring up. Being familiar with berms and impoundments and the equipment that it takes to, sorry.
Mr. George.
yeah, go ahead.
You know, the need to have excavators, dump trucks, and other equipment to properly maintain them. It seems like the buffer and the ability to get the equipment there to maintain it would be conflicting. In other words, you'd have to cut buffers back down to get the equipment on there to maintain the berm.
I guess
so
my
that's
thought-
where I'm kind of, I understand the requirement, but in practicality,
Well, my thought is that variant, once the road is constructed, is there in perpetuity, that the application of special condition 2 would be relative to the other land disturbing activities that would occur on the property, not the road itself.
I would go along with you, with the exception, I think we need to include criteria 4.
So I was going to mention that criteria 4 would be a requirement because recreational vehicles on parcels are not allowed without a residence. And then also all storage containers do have to have a zoning permit as well.
I guess, are we allowed to talk with staff now? I mean, we're past staff question time, but does the county enforce on hunting properties? There are a number of RVs that exist on hunting properties throughout the county. Do you ask those guys to remove their RVs when they're discovered on a?
So in order for a recreational vehicle to be on the parcel, the ZELDAR requires that there be a residence, that recreational vehicles can only be stored on properties as storage only.
So the answer is
Not-
yes.
The answer is
And
there's
this
probably
is
a
a-
lot that are not known about. And
This property is a little different because it's residential. It's rural residential and it's not considered ag. So it does have some different requirements in the ordinance for accessory uses like
if it were
accessory.
ag, would they be allowed to have the RV there without permission from the county?
No.
Not ag.
I mean,
But
this
you
is
could
curious.
have storage structures. You still need a permit, but you could have that if you were ag,
Ms. Manel,
the storage.
everything they're saying is exactly right. You can have it stored there, you just can't have someone staying in it or have it hooked up to power and being utilized. You know, you have to have a septic tank. Another thing is the county will extend it if you have a building permit at hand for your residence that will let you put your RV out there and stay in it while your residence is being built.
Right.
So there are some allowances, but yeah, she's right on. So I could see that. I think that is a reasonable request to have those removed. If you would
So
support that.
you would want to include special condition
Only
4?
just for that she is right. I mean, that is how it's applied.
Okay.
Mr. Marchant, you had a question?
Call for the question, Mr. Chairman.
So are you
I mean,
willing to?
I would be willing to
amend?
amend to add 4
Okay.
if that's the pleasure of the board. And so.
Well, you have to ask the second there.
So 4, would you be
Yes.
okay with that? All right. So I will amend the motion to add special condition number 3, because we can't have a 3 without a 4, right? So we're not going to have the one listed by staff. So the third special condition would be the applicant shall remove all necessary uses, recreational vehicle campers and structures, storage containers from the parcel until a principal use has been permitted. All accessory structures shall require permits.
That's your motion.
That's my motion.
Is that still your second?
The second.
Okay. Now we have a motion that has been properly moved and second. Are we ready for the question? All those in favor, please indicate by saying aye. Raise your right hand. Aye. Oh, it is unanimous. Good. So there. Within 10 days, you'll get information from staff letting you know the next steps in this process. Congratulations.
It's always a pleasure.
All right. Very good. Okay. 2 down, 3 more to go. Our next case is case BZA-09-22-00613, and that will be completed by Ms. Working.
All right. The applicant and property owner Grace Cribben of 3718 Betsy Carrison Parkway LLC, represented by Trey Litton III of Forsberg Engineering and Surveying, Inc., is requesting a variance to reduce the required 50-foot right-of-way landscape buffer along Betsy Carrison Parkway by 5 feet to 45 feet for a proposed commercial building at 3718 Betsy Carrison Parkway, which is TMS number 20200000243 on Johns Island in Charleston County. The subject property and surrounding properties are located in the Community Commercial CC zoning district. The applicant is in the site plan review process for a proposed 40-foot by 120-foot home retail warehouse building on the 0.749 acre property. The applicant's letter of intent explains, in quote, currently along Betsy Carrison Parkway, the frontage of this proposed project is an existing 50-foot buffer. The proposed projects request that the frontage buffer be reduced to 45. The landscape planning plan will still provide the same number of plantings that will be required as part of the 50-foot buffer. These are the ordinance requirements. Aerial photo and zoomed in, zoomed out. As you can see, it's a corner of River and Betsy, where Betsy meets Bohicket. We conducted a site visit on the property on October 18th, 2022. And here are some photos of the subject property, more photos, and some surrounding properties, and then Betsy Carrison Parkway. Regarding the approval criteria, we stated that it meets 1, 2, and 5, and that it may meet 3, 4, 6, and 7. The board may approve approval conditions or deny this request based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, staff recommends the following condition. 1, prior to zoning permit approval, the applicant shall complete the site plan review process. And this is just a survey of the property, site plan and landscape plan that I showed earlier, and the plats. Any questions?
Anybody has questions of staff? Thank you, Ms. Working. Is the applicant available? Very good. Please state your name and address, and please tell us why we should approve your application, sir.
I'm Trey Litton with Forsberg Engineering, 1587 Savannah Highway, Charleston, South Carolina.
Please come a little closer to the mic.
Oh, sorry.
That's okay. Thank you.
I appreciate the opportunity to discuss this request. There's a few items I want to highlight. Number one, county arborist. There are 2 grand live oaks on the property, and we met with the county arborist on site. We coordinated our site plan with county in an effort to limit the impact on the grand oaks. This resulted in pushing the building closer to Betsy Garrison. As far as criteria 3 and 6 are concerned, the existing conditions, as it is currently, there is no vegetation in the existing buffer. It is only grassed. Even with buffer reduced 5 feet, we were able to meet landscape buffer requirements for the full width. For this site, it includes 12 canopy trees, 17 understory trees, and 95 shrubs. We've already submitted plans to site plan review with landscape plans providing plantings for full buffer width. Additionally, the total site is 0.74 acres. The reduced buffer will represent 25% of the property. And that's with the reduced buffer. Additionally, with the 8-foot vehicular use buffers on the sides and with the tree protection zones for the large canopy trees, we have over 48% of the property that will be buffered or preserved. Criteria 4, adjacent property. The other developed property along Betsy, as part of the larger Island Track Center, this is an out parcel in the Island Track Center. In this complex, there's a parking lot adjacent to this site with no buffer between the parking lot and Betsy. Therefore, our proposed development should not be a detriment to adjacent properties. Happy to answer any questions y'all may have.
Okay, thank you. Does anyone have a question of the applicant? Oh boy, you got off easy today. Thank you so very much. Thank you. Does anyone else want to speak in favor of this application? Do we have anyone that would like to speak in favor of this application? Do we have anyone to speak in opposition of this application? Do we have anyone to speak in opposition? Okay. This matter is closed to the public. Board members. Do we have any questions of staff, or we have any questions, or can I get a motion to approve or deny?
I'll be happy to make the motion, Mr. Chair. In the matter of BZA case 09-22-00613, I move that we approve the application for the variance. I find that it meets all of the criteria. It meets criteria 1. There are extraordinary and exceptional conditions pertaining to this particular piece of property. The amount of required setbacks and buffering has greatly reduced the buildable area, and it is being used as a commercial use. It meets criteria number 2. These conditions do not generally apply to other property in the vicinity. The adjacent property has no buffer. It's a hardware store and other commercial use in a parking lot, and there's no buffer whatsoever. And I don't think it has the trees on it that this particular piece of property has. Criteria 3, because of these conditions, the application of the ordinance of this particular piece of property would effectively prohibit or unreasonably restrict utilization of property. I find that it would unreasonably restrict the utilization of property, so it meets criteria 3. Criteria 4, the authorization of the variance will not be a substantial detriment to adjacent property or to public good or the character of the zoning district. It's commercial right there. It's a hardware store, asphalt parking lots. This property will actually have a substantial buffer and maintain its grand live oak trees. So it absolutely meets that criteria. Criteria 5, the Board of Zoning Appeals shall not grant a variance, the effect of which would be to allow the establishment of the use not otherwise permitted in the zoning district. It meets criteria 5. Criteria 6, the need for the variance does not result in the applicant's own actions. I find it meets that criteria. It's dealing with, I'm happy to see a reduction in a buffer to save grand live oak trees. Criteria 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. I find it meets that criteria. I would include staff's one condition: prior to zoning permit approval, the applicant shall complete the site plan review process.
Okay, we have a motion. Do we have Mr. Marchant? Thank you for your second. Any questions of staff? Okay. All those in favor, please indicate by saying aye and raise your right hand. Aye. Oh, it's unanimous. Congratulations, sir. Within 10 working days or business days, you will get information from staff letting you know the next steps in the process. Congratulations to you and your clients, sir. Come on, here we go. All right, we're moving rather well. So our next case will be done by Ms. Sally Brooks. It'll be case BZA-09-22-0061. Thank you, Ms. Brooks.
Thank you. Yeah, it's been a while. What a treat.
It has. Glad to have you back up there.
The applicant, Thomas Kellum of Kellum Engineering LLC, is requesting a variance to remove 2 grand trees located in the Resurrection Road right-of-way and ingress-egress easement in order to construct a paved road for a proposed subdivision on TMS 204000014 and 017, and to provide access to Betsy Carson Parkway for several parcels on Johns Island. The Charleston County Public Works is the property owner of the Resurrection Road right-of-way, and Hallover Creek Partners LLC is the property owner of the easement. The first half of Resurrection Road borders a property to the south under the jurisdiction of the town of Kiowa Island. The project area and adjacent properties are located in the low-density residential R4 zoning district. The applicant's letter of intent explains the request. These 2 tree removals will allow for the construction of a paved road to serve the proposed 34-lot subdivision, as well as provide an improved access, allowing emergency vehicles to serve the 7 parcels accessed by Resurrection Drive, end quote. The 2 grand trees are located approximately 100 feet down Resurrection Road on the right-hand side after turning off Betsy Carson Parkway. The 2 proposed trees for removal include a 27-inch DBH laurel oak, grade C, and a 34-inch DBH live oak, grade B. The subdivision request is currently in the review process. So here you'll see the aerial of showing Resurrection Road and some pictures of the site visit on October 17th and 18th. And here's some photos of the trees. And surrounding properties. So the Planning Director review and report regarding approval criteria of Section 3.10.6. Based on the staff review, the project the application may meet all criteria except for criteria 6. The need for the variance is not the result of the applicant's own actions. The staff's response is the applicant's letter of intent states, quote, construction of a roadway that can provide 2-way vehicular access cannot be achieved without the proposed variance tree removals, end quote. The removal of the 27-inch DBH laurel oak would be necessary. However, staff's review shows the tree protection barricades and limits of disturbance to be approximately 6 feet off the trunk of the 34-inch DBH grade B live oak tree. Complete removal of this tree may be avoided by the applicant working with a certified arborist to develop a tree care plan and to monitor the tree before, during, and after construction. A variance may be approved for encroachment into the critical root zone, but removal of this tree may not be necessary. Therefore, the request may not fully meet this criteria. So for the action, in the event the board decides to approve the application, staff recommends the following conditions. Condition 1, prior to construction, the applicant shall install tree barricades around all grand trees and protected trees to be preserved within 40 feet of disturbance associated with the project. Pursuant to Section 924 of the ZLDR, all barricades shall be inspected and approved by planning staff prior to construction. And condition 2, the applicant shall mitigate the removal of the 34-inch DBH live oak and 27-inch DBH laurel oak by depositing funds into the Charleston County Tree Fund as described in Section 926 of the ZLDR, the allotted mitigation shall be in place prior to removal of the tree. And we didn't get to the site plans yet, so I'll just like flip through these. There's a zoom in at the bottom left corner of the plan, and you'll see 2 red X's, and those are the 2 trees in question. And then there's a larger plan of the entrance from Betsy Garrison onto the road. Okay, and the plat of the property. Are there any questions?
I have one I'd like to start off with, if you don't mind. You gave that lower oak a C grade. Could you tell us why?
So those were grades assigned by the arborist that was hired by the applicant. So they may be able to elaborate more on that. Chris Dubuque did the site visit for staff, and we reviewed several trees while he was out there, and these were the trees determined not to be dead, diseased, or dying during the site visit. So that's why these 2 were chosen. You'll see some other X's on the other trees, but they were determined to be in poor health at the site visit, and those were approved administratively for removal.
Okay, thank you. Mr. Borkin?
I'm going to ask you a question, Ms.
Okay.
Brooks, but first I would like to ask Mr. UG a quick question. Is it within the power of this board to approve one tree and not another? Okay, thank you. So now, following up on that, you've assessed the grand live oak tree. In your opinion, as an arborist, do you think we can save that tree potentially if certain steps are taken to mitigate?
Yeah, it could be.
Okay.
There could be potential for that. Yeah.
Okay.
Or if you wanted to grant, to try to work around it, but if the tree were to decline or something, that would.
Is the issue root disturbance or root impact, or is it excessive pruning that'd be required for that tree to remain and effectuate a 2-lane road?
Yeah, so it would be the root disturbance would be the main concern, because the improvements required to the road to bring it into compliance with like the road standards and require a widening of the area, and so that sort of gets into.
The only reason I bring this up is, driving on Johns Island roads every day, we've got tons of trees that are encroaching under the pavement, and cars are driving over them all the time, and they're still going strong. So I just want to bring that point up. Okay, thank you.
Mr. Marchant?
Just to follow up on that question, did I hear you say that in your opinion, or in staff's opinion, that both of these trees could be saved and a road could be built?
No, it was
Live oak.
just potentially the live oak.
Okay.
Anyone else?
Are you sure about that? I heard something different.
Yes.
Okay. Thank
Yes.
you.
And that it might be something better to talk with the applicant over that concern, but from the staff point of view, it could be possible to do that.
All right. Is the applicant present? All right. Please state your name and address for the record, and please tell us why we should approve this application, sir.
Thomas Kellum with Kellum Engineering, 634 C Marina Drive, Charleston, South Carolina. I think the staff has gone over it pretty thoroughly. Our application. Give a little background. Resurrection Road, the existing dirt road, crosses out of the county right of way and onto private property. That's historically been that way. Our client originally, upon looking at this property, realized that there was not legal access to their properties, as well as multiple parcels that are served by Resurrection Road. They worked with county staff to identify some concerns there. They approached the property owner to which Resurrection Road weaves onto and acquired an easement, so there now is legal access at least to their 2 parcels. There are multiple parcels that are still served by Resurrection that do not have the legal right to use that dirt road as it is now. As part of their proposed improvements, when this road is paved, it will either become a private right-of-way or it can be taken into the county system should the county want to do that. To the point on a couple of questions, the laurel oak cannot be saved. The 34-inch live oak, our intention was to save that. We've worked with county staff over the last year to look at some layouts. We're going to attempt to super elevate the road there to minimize root impacts. And the intention, at least on the initial variance application, was actually to save that tree. When we started looking into it, we're going to be about 6 feet off of the trunk of the tree. That gets into where we're closer than 3 times the diameter breast height to the trunk of the tree there. We'd be happy to attempt to save the tree if it goes into decline and we need to do something. Otherwise, we can do that. I think that's pretty much, all we have. The site itself, we've worked with county staff internal to the site to save all Class B trees, walked it with the county arborist. We're, doing the best we can to preserve everything on site.
Okay. Any questions? The applicant?
Just a quick one.
Yes, sir, Mr. Boykin.
Mr. Kellen, I applaud your interest in saving the tree, and I'm inclined as a member to grant your variance if it comes to a vote for the laurel oak. But it does make me happy to hear you are willing to work with the county, and we'll have a condition if that were to happen.
Yes, sir. Thank you.
Yes, sir.
Anyone else have a question of the applicant?
So just as a point of clarification, with the live oak, we still would need to approve the encroachment part of that, and which is fine as part of this.
Quick question. Would they have to come back for yet another variance? Is that something staff can do?
Yeah, it would be fine as part of your overall approval if you just made that like a condition or something. Yeah.
Okay.
And if I can speak also, I guess it would be a twofold encroach. So we're over the 25% encroachment, and then we're also closer to the trunk of the tree than that requirement as well.
Yeah, so I mean, by definition, it would probably still qualify as like removal. So, but in a way that.
I guess let me go all the way around here. What language would you like in a condition to give you the authority to oversee the arborist monitoring and encroachment issues?
Yeah, so in these situations in the past, the language that we've used is something like to monitor the tree within 3 years of construction. If the tree were to die, then mitigation inch per inch or something like that would be paid at that prior to the removal of the tree, usually.
Because you couldn't replant, so you'd have to mitigate it.
I think it would have to be just given the site conditions, we don't have a lot of room on site to be able to plant mitigation.
Yeah.
Yes, sir. So we would pay
Right.
to the bank.
Any other questions of this applicant? Thank you, sir.
Thank you.
We have anyone else to speak in favor of this application? Do we have anyone else to speak in favor? Do we have anyone to speak in opposition? Okay. I see your hand, young lady, first. If you would please come forward. Please state your name and address. Yes, I said young lady, you first, looking back.
And also, just to point out, there were 4 letters in your, of opposition in your supplemental packet.
Thank you. Please state your name and address for the record and tell us why we should disapprove this
I
application.
am Louise Bennett. I live at 3205 Resurrection Road, which is the last house on Resurrection Road. Actually, it is the house that Betsy Carrison built. And we have preserved it as best we can as she had it. And I feel that her spirit is still there. And Betsy Carrison did a lot for Charleston County and was on Charleston County Council. I am against the removal of the trees. I am against paving the road. First of all, we have been blindsided by Hollover Greek LLC. They bought 2 surrounding properties of our property, one of which we had tried to buy for a number of years and we were refused. And this is not sour grapes about that. But everything we've tried to find out about this proposed development, we have found out absolutely nothing. The first we've known about a housing development, and tonight we hear there's going to be 34 houses on less than 16 acres. That's the first we've known about it. And the whole process is disturbing to me that now we can remove trees to pave a road going to a subdivision that we've seen no plans to. On the right going in Resurrection Road, on the right hand beside Berkeley Electric substation, and then on the left side going down beyond MC Hayward's property, and on the other side of the Smith's property, and then around our property. It is just disturbing. And I think the residents of Resurrection Road, there are 3 of us here tonight, would like to see some sort of plans for this development first.
Okay.
Thank you.
Hold one moment, please.
Yes.
Let me see if we have anyone of this august body that has a question for you. Does anyone have a question?
I'll ask us for a quick one.
Mr. Borkin?
I guess one of the issues is, I absolutely understand the concern of the tree, and we want to do, I personally want to do all we can do to save the tree. Do you know who owns the road where the trees are located? Who is the rightful owner of the dirt?
MC Hayward owns the beginning of the road,
Right, where the trees are, I guess is what I'm
where
asking.
the trees are.
Okay.
At least he did when we moved there. And we were grandfathered in legally to have access to our property.
Right. Do you know that the person Mr. Kellum represents, do they now own that road?
Pardon?
Do you believe that the person Mr. Kellum represents now owns the right to that road or owns the property that road sits upon?
The town of Kiowa bought, I know they have part of it. Exactly where the right-of-way is legally, I don't know.
Is the road privately owned?
A portion of it was when we bought our house.
I understand.
Betsy
I guess what I'm
Harrison.
asking is,
And
do you know
Betsy
whether...
Harrison was grandfathered in on the road, and then we were too. And according to the knowledge that we have, MC Hayward.
Well, I guess what I'm bringing up is all we can consider is the encroachment on the tree tonight and the removal of the other tree. I would presume that the applicant has legal authority or legal dominion over that property to come to this board and ask for such things. Right. I'm asking if do you say otherwise?
I mean, if they bought it.
Well, that's what I'm
then
asking
they
you. Okay.
bought
Yes. Okay.
The easement.
Right. And so if they bought it, they own it.
Right.
And so whether they pave it or not is their call because it's their property.
Yes, but they don't own the rest of the road.
I'm only speaking of the part that they own. I don't think they can go pave someone else's road. That's what I'm trying to say. I think they're limited to only the property they own or have title to.
Well, then it's going to be a very strange road.
I can't speak to all that. I'm just saying the matter for this board tonight is only where these trees are located, and he would have to own that property to encroach upon those trees or ask for a variance.
Let me see if we have another question.
Who performs maintenance on the road?
The county.
The county. So the county should know who owns the road then, or is it the county owns it?
The Hollover Creek purchased part of the easement from one of the parcels, and then the county owns the road.
And maintains it?
But they're not I don't know about that. They're not going to pave it. It would be the private property owner if this was approved.
It's a dirt road?
Yes.
Somebody grades a dirt road every now and then, don't they?
The county grades the road.
Thank you.
Let me ask Ms. Working a question. This is where things are getting kind of muddier as we go. If the county's scraping the road or maintaining the road and the county owns the road, how can they ever pave it? Because it's not private, it's public. That's my question. Who owns the road? I mean, is this easement even proper? I mean, this request even proper? Because do we have a clear understanding of who owns the dirt those trees are next to?
Public Works, we had them sign the application, so they're aware of that, this application. They don't support the application or not support the application. They're just aware that this person
So my
has
question
made
is,
an
how does this applicant have any right to ask for a variance on property that's owned by Charleston County?
That's what I'm saying. They signed it. The trees are on Hallover Creek and Charleston County's property.
I'm not sure I'm
the
clear.
tree- the trunk of the
Can you
tree
weigh in on
is-
this?
There's an easement ownership and a right-of-way
Yeah.
ownership, and the right-of-way is by the county and the easement's by his client.
Come to you.
Yeah,
Go-
you have to zoom in on that so you could see it, the road profiling.
It's complicated.
Yeah.
This is getting more by the minute. Mr. Eugene?
I'll get you a question. Go ahead. Go ahead.
Go ahead.
Go ahead, Mr. Huger. Go ahead and make for clarification.
No. So what does your client own?
Pardon?
I'm sorry, I'm going to ask the applicant a question.
And may I add one other little tidbit to all of this?
Go right ahead.
One of the county employees who used to drive whatever machine it's called, the grader, lives on Resurrection Road. He is here tonight, over in the corner, Vernon Smith, and he's signed up to speak as well. He was asked to sell his property, and he refused. I'll let him tell you about his refusal.
So
Thank you.
that's fine, ma'am. Can the applicant please come back?
Yes. So Charleston, there's an existing 25-foot wide right-of-way that Charleston County owns. And that
Is it the length of the length of this road?
it is the length of it. It ends at the end of Mason Hayward's property, so it does not run internal to serve the property in question, or who the madam just spoke to. It ends.
Can you go to the third one?
So,
No. Back at the very beginning, if you go to the third slide.
Mr.
That
Chairman,
one right there.
Mr. Chairman.
So at the end, I'm sorry to interrupt. So at the end of 018, that is where the Charleston County easement, or excuse me, Charleston County right-of-way ends. Our client then purchased a variable width ingress, egress, and utility easement in order to extend that. I think it's a minimum of 50 foot for the length through -018. And then at that point, Resurrection Road, it becomes on our property. It is not within an easement to serve those parcels. I'm not an attorney, but as far as being grandfathered, I don't know if that's the case. I know our client paid a substantial amount of money for that easement for them to have the legal access to access their property.
Okay, I got a question over here. Not you, Mr. Marchant. Go ahead, sir. Yes, sir, go ahead.
So you said the Public Works signed the application for the road?
They signed for the tree because one of the trees is on one of the trees is on the part of the right of way that they own.
So they signed as representative of Charleston County? Who do they sign as?
So when you have to have an owner sign, this
That's
person,
what I'm getting
all
at.
over.
Who are they representing as owner? Public Works signed it, so who owned it? Who are they representing?
So representing anyone.
County?
We need an owner's signature on a form.
So who?
It doesn't mean that the the Public Works doesn't have anything to do with the application itself. They're just signing that they own the property. We need a.
That's what I want to hear.
owner's
They signed as they own the property.
Because they own part of the property where the tree is
Thank you.
located.
Yeah, so
Someone said
that part of the road is part of the county non-standard road program. And in order for the improvements for the subdivision, the road has to be improved to meet a standard, because it's a non-standard road right now. So the county's not going to do the work. The developer has to upgrade the road in order to.
So that,
Right.
I got you. Mr. Huger had a statement and question that he wanted to present.
No, I was just trying to, so which prop your client owns, all of the, in yellow, it says R4? Is that where the development is going?
No, so that a portion of that R4, yes, or yeah, but it does not. There's some missing parcel lines there, I guess. It does not wrap all the way around to Betsy Carrison. There is no other access to these parcels. There's no way for them to access Betsy Carrison other than through Resurrection Road. And we can't shift the road any further away from the trees and meet county requirements.
Mr. Chairman.
Yes, sir.
If the board will go to the last exhibit in your packet, there's an engineering drawing, and that drawing, it's the survey, and you can see the portion that the county owns, which is a 25-foot wide section of right-of-way.
Can we go to that one, please?
You're not going to be able to see it on this screen, but the and then there's a small sliver. I think you said variable width.
Yes, sir.
That Hallover Creek LLC owns, and that takes you back to Hallover Creek LLC's main 12.8 acres. So you can see the challenge between, and unfortunately on this plat, which you're not going to have anyway, the trees are not going to be shown. So it's complicated because you got an owner in the county, you got an owner in a private developer. The tree may straddle those two property lines. They may be on one. We don't know.
One point of clarification.
Based on the information we have. So
Go ahead, Mr. Boyd.
And Mr. Eugene can answer this. Does the signature by an official of our Public Works Department constitute assent for tree removal on the part of the county's interest in this matter? Without seeing the document, without seeing the signature, I have no way to know, and I'm asking that question because this gets in the game of, do we have all the parties involved saying, yes, this is what we want?
The county signature is in the application.
What does that signature represent or signify is what I'm asking. It's just, yeah, we know they're going to ask for a permit, or yes, we're okay.
Correct, because without that, they can't move forward.
Okay.
By signing it, they're
so that
not
constitutes assent on Charleston County's part.
aware
They're
that this
fine.
applicant
They don't have
would like
any
to remove the
objections
tree.
to it, and I guess for county authority, that meets
Yes.
that criteria. Thank
Yes.
you. That's just want to make sure I got that
Yeah,
point right.
they
Okay.
just,
They're signing off as the owner.
Make sure we,
Yes.
okay.
Yes.
I didn't want a interested party not to wait in. Thank you.
Yes. Okay, well, that was good. Unfortunately, you got to have a seat. All right. Do we have anyone else to speak in opposition to this application? Yes, sir. Mr. Downey, could you probably lower the mic for him, or whoever's closest?
It's really weird because you see what it is here. That's probably.
Thank you, sir.
Knock it over.
Good evening, sir. Yeah, you're going to do well. Please state your name and address for the record, and tell us why we should.
My name is Sarai Limehouse, 3205 Resurrection Road.
Yes, sir. Please tell us why we should deny this case. Mr. Limehouse, correct?
Yes, sir. All right. I know we're talking about two trees, and I know you got to make a decision on these two trees.
Mr. Downey.
But, let me, I got it, okay. But, you know, I've lived on Johnson all my life. I've lived Resurrection Road 26 years. We got a nice little neighborhood back there. Everybody's friendly. And for, I don't know, 20 years. Paid $200, which paid the taxes for the man who owned it. And then
I cussed him out because he didn't offer me the land. He just sold it. I don't know. Somebody, all these people are interested in is making money. They don't care about our community. Okay. We got 3205 Resurrection Road. That's where I live. That's where Louise lives. Next door is Ayers property. Next to Ayers property is Vernon Smith. But the whole problem with this whole thing is, in the war between the states, however you want to call it, the Union forces decided that they were going to come on Johns Island and create a diversion. The Confederate camp was in Adams Run, South Carolina, and the railroad ran right through there. All right. They thought if they could come from Folly Beach, come through Kiowa, come across the Haulover, and act like they were going to attack Charleston from the same way that Cornwallis did in the Revolutionary War. So they sent 2,500 men to the beach through Kiowa, and they came on to Johns Island, and they established a defensive line. And that defensive line is on Resurrection Road. Okay. We have I didn't bring a picture. I've got pictures of, you've got them? Okay, we got, of NMC Hayward's yard, right next to the road, is a cannon mount. Behind, on the, I guess you call it the, away from MC's house, there's a bank this high, built by I'm sorry. Built by newly freed African American slaves. And this proposed road goes right through that. The trees, two trees we're talking about, nobody ever marked them. Nobody's told us anything about these people. They're Greeks. I don't know, all over Greeks. I never heard of them. But I do know that I'm 84 years old. Not this wheelchair, because this wheelchair belongs to the county, but I'll be in my wheelchair just in the middle of that road before anybody touches those trees.
Mr. Limehouse, unfortunately, your time has expired. I hate to do this to you, but won't you tell me about these pictures real quick? The pictures that you presented to staff.
Oh, that's a gun mount. That's a cannon mount.
And how does it have effect on these trees that we have here, Mr. Limehouse? That's what I have to get to.
There's, I don't even know where the trees are. Trees were never marked. I live down there, Which trees are there? I don't know. But I do know that before they come down that road, I'll be there in my wheelchair. And I'll have everybody, newspaper, TV, national people, NAACP, anybody and everybody I can get to stop that.
Okay. Well, Mr. Limehouse, let me see if anybody else has a question here for you. Does anyone have a question for Mr. Limehouse? Okay. Mr. Limehouse, thank you so very much for your testimony today, sir. We appreciate it. Everything that you said.
You've got to show me the two trees.
Well, we've
Can
had
can someone just show him here?
please put the 2 trees up there, if we could.
Are you able to see the screen, sir?
Go back. There you go. So those are the 2 trees that are in question. You have a laurel oak and you have a live oak, Mr. Limehouse. Do you see the trees, sir?
I see the trees, but, I drive down that road every day, and I can't. I can identify the one on this side, but the other one I can't. I can identify the one on the left, but I don't know where the one on the right is.
Okay. But once again, Mr. Limehouse, thank you so very much for your testimony today. Thank you, sir. Do we have anyone else to speak in opposition? Yes, ma'am. Please come and tell us something different than what we've heard thus far. Please state your name and address for record. Thank you for lifting that.
Good evening. My name is Nancy Harold. I'm at 4454 Betsy Carrison Parkway. So we're on the creek side. I have a couple questions. Is it Haulover Greek or is it Creek? Because all the paperwork is Greek. It's not Creek.
It's Greek.
So initially we thought it was a typo. So can you tell me, is it Greek?
Please
Address your
the board,
questions
sir.
this way.
Ma'am, please address the board.
Okay. Is it Greek or Creek? Haulover Creek LLC or Haulover Greek LLC?
Just tell her who's the name of the applicant.
It's
Because there
Greek.
was-
It's Greek.
Yes, okay. Because there was a tax lien on the property that we're talking about for $164. And I did see the address and I went there and there is an Greek Orthodox church on Rice Street. So that's clears that up. Thank you. And as far as the Civil War impacts and things like that, we have found Confederate coin, we have found Confederate buttons, we have found irons from a laundry on the plantation where our property is. So, I understand that it's 2 trees. I'm against the development. I'm against the fact that if any of you, and I'm sure Mr. Boykin has driven down Resurrection Road, it's a destruction of the area. That's all I have to say. Thank you.
One moment, if you don't mind, please. Let's see if anyone has a question for you. Does anyone have a question for you?
Yeah.
Okay. Well, thank you so very much for your testimony. Do we have anyone else to speak in opposition? Yes, sir. Please come forward.
They said they bought the easement from the county.
Thank you, sir. Please state your name and address for the record, and please tell us why we should deny this application, sir.
My name is Vernon Smith.
Please
I
lift.
live at 3229 Resurrection.
3229 Resurrection Road?
Yes, I'm one of the heirs that own that property. I just stand up to say, all of this is all very new to me. I learned about this tonight coming here. All week, I was laying plastic, planting strawberries. I saw the severes going in and out, but my family and I, we don't know nothing. But I know now because I attended this meeting. I just stood to say that.
Okay. Can you pull up the map of the property with the general one, this one?
Zoning.
Yeah, yeah. Which one of those is your property, sir? The 027, 19, 133, 108.
On the right of the road, Resurrection Road. It's not just beyond.
It's not listed on there?
This map just has the
Portion of it.
the parcels that were in the radius. So there are a couple that are,
Back a little further.
yeah.
Okay.
But I'm just beyond MC Haywood's on the right
Okay.
and right before Side Eye.
Okay. And you got the notice and you saw it in the newspaper?
No, I saw the sign to the head of the road. They did put the sign there. I read it. That was just right over my head. And didn't know what they were trying to do.
Well, I'm glad you came out so you can find out more. Okay. Does anyone else have a question of this gentleman? Thank you so very much for your testimony, sir. Do we have anyone else to speak in opposition? Very good, sir. Please come forward. Please state your name and address for the record, sir, and tell us why we should deny this application, sir.
Yes, sir. My name is Collie Farah. I live at 992 Foxcroft Road. I am here on behalf of the Kiowa Conservancy.
Okay.
And the reason that we are in opposition of the removal of these trees is that with removing those trees and allowing for widening and paving, there is that's going to add more impervious surface to the area that is undoubtedly going to allow for more flooding in the surrounding and adjacent properties. A recent ordinance was passed by Charleston County Council to help limit the amount of impervious surfaces going around Charleston County, and that was done so for a reason. And by just removing these trees, that is undoubtedly going to allow for more flooding in the area. And not to mention the fact that these live oaks are home to hundreds of different insect species, and removing them just hinders the wildlife value in that area.
Okay. Mr. Borkin may have a question for you.
I do. Are you familiar with Resurrection Road pretty much?
I am, yes, sir.
Do you know some of the people that live there?
Yes, sir.
Do you travel it yourself?
Yes, sir.
Have you ever seen any traffic impairments or congestion with the road in its current state?
I have not.
Okay.
Well, let me restate. Yeah, sometimes it's very tight for two cars to get there, sure.
The people generally just pull to the side where they've got room and let somebody get around them. You know, I realize the entire road is not of width.
They're very cordial, yes.
Okay. So no issues with the road as in its current condition?
Not for the amount of people that currently live there.
Okay. All right, thank you.
Does anyone else have a question for this gentleman? Thank you so very much for your testimony, sir.
Thank you.
Yes, sir. Do we have anyone else to speak in opposition? Thank you, sir. Please come forward. Please state your name and address for the record, and please tell us why we should deny this application.
John Zloger with the Johns Island Task Force, 5528 Frisco Lane, Johns Island. I kind of had written down a lot of stuff, but I think at the end of the day, the question isn't really about two trees. It's really about do they meet their criteria? And really, it sounds like this nice road, the main reason to get rid of the two trees is to increase the value of the property that they bought in 2021. I mean, this is not people that have owned this property for years and years. They did their due diligence, as the person said. They knew there was a problem with this road. So the assumption was that they could develop right now they could develop the land however they want without destroying these two trees. They bought it that way, and a little bit over a year ago. So the question is, does it meet all the criteria? And we don't believe it meets criteria 3, because with these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. When they bought the land, they knew exactly what they had. They knew exactly the restrictions of the two trees. They knew the amount of traffic that was on that road, the fact that it was a dirt road. All that was known. So it's not restricting anything from the standpoint of the pre-purchase. What they want to do is, after the fact, increase the value of the property by making these changes. So we believe it doesn't meet criteria 3, and we recommend that you deny this request. Thank you.
Okay. Hold on one moment. Does anyone have a question of him? No? Thank you so very much for your
Thank you.
testimony, sir. Do we have anyone else to speak in opposition? Do we have anyone else to speak in opposition? Okay. So at this time, sir, you have the right of rebuttal.
Just to touch on a couple of things, as far as criterion 3, the property is restricted in its current state from emergency vehicle access, be it fire and ambulance. The current road will not support a fire truck. Certainly, the current road in its condition will not support a fire truck, certainly not during a storm event, as ambulance either. We're looking to improve it to meet minimum county road standards. In regards to flooding, we'll work with Charleston County Public Works through that to do extensive stormwater analysis. We're very close to the adjacent receiving water body. This is not going to cause any flooding issues to neighboring properties or downstream. We did, Mr. Limehouse and I spoke extensively on the property a few months back. He did relay to us some of the Civil War berm concerns. We will work with Charleston County and SHPO to make sure those are vetted. Not that that is necessarily the board's concern, but all of these concerns have been heard. We are going to work through them. We'll be working very closely with Charleston County Planning and Zoning and Public Works, as we move through this process. And I understand the opposition to the development itself. Our request today is for the 2 trees at the front of the development, or excuse me, at the front of the property to be able to access this and provide emergency vehicle access to these parcels and also to the parcels in opposition. Thank you.
I'm going to start with Mr. Jordan first.
So prior to this, has there ever been any problem with the fire department coming down that street?
I'm not familiar.
Was anybody familiar?
Well, we have to address him, Mr. Jordan.
I understand, that's
Yes,
why
sir.
I'm doing that.
Okay.
But I mean, those people live there, I'm assuming, a long time. Fire trucks must go down that road sometime.
Code requires a 20-foot wide road, and it needs to be able to support the load of a fire truck, which the current road does not meet that criteria.
Mr. Marchant.
Yeah, I mean, I think the point about criteria number 3 is a good one, and something I've been thinking about as well. And it's partially why I asked the question to staff: could we build a road without removing the trees? This is not about the 30-something homes. That's a different issue. But it's about, can a proper road be built without removing trees, or does removing the trees require us to build a proper road, right? And so I guess my ultimate question is, could you build a road that would accommodate life safety vehicles without removing trees? Could you do that?
No,
Impossible.
Sir. No, sir, it's not.
Okay.
So the current alignment, we're pushing the back of curb to about a foot off of the easement. So there is no more room for us to push away. The laurel oak is within the easement. The live oak is within the Charleston County right-of-way, and we can certainly make all efforts to save that tree, and we'll do so.
Thank you.
Mr. Nelson.
Just for a point of clarification, who did you buy the easement from?
From Mr. Hayward.
Okay. Yeah. So that has the flag-shaped lot and then the lot behind it on his
yes,
property,
sir.
right?
Yes,
Okay.
Mr. Borkin, you had a question?
No, sir.
Ms. Wilson-Smalls, you want to get in on this?
No, it's just, it occurred to me that we've seen these cases before where developers come and go into these historic communities without talking to the folks within those communities. And as a result, we end up with all this opposition that shows up. I mean, you said you spoke with Mr. Limehouse, but did the developers speak with any of the other folks within that community? And that would just be, a general question.
Yes, ma'am. I'm not familiar if they have or not. We can certainly make those efforts moving forward.
And particularly, I think they, if you buy a piece of property tucked way back in there with no access, you kind of know what you're getting when you purchase it.
Very good. Anyone else? I think they heard from everybody on the board. Thank you so very much for your testimony. Okay, this case is now closed to the public. Thank you, staff. Do we have any questions of staff?
It's got a motion.
Any questions of staff? Mr. Jordan?
How about my fire truck question? People live there a long time. Fire trucks have been on that road? They must have. Or have they?
I don't know the answer to that. No, I'm sorry.
Any other questions of staff? Mr. Nelson?
Um,
I'm sorry. I'm sorry, this discussion, I'm sorry, it is closed to discussion.
About fire trucks coming down the road.
I'm sorry, I can't address anything that you have to say at this time. I'm sorry, it is closed to the public. So right now, it's just the board. If you would please just have a seat and let us do this. Thank you. Thank you for your, Mr. Nelson?
the zoning on the property is R4, correct?
Let's get back to that. Here we go. All the way back? Yep, there you go. Yes, sir.
And the development plans that have been included with the application package are consistent with the R4 zoning, right? It's all within the by right zoning for that property.
Any other questions of staff? Okay, ladies and gentlemen of the board, if we're clear with all our questions, I'd like to get a motion to either approve or deny this case. Mr. Borkin, I see your hand right there in the corner of my eye.
I'll make a motion, Mr. Chair, in BZA case 09-2200614, that we deny the application based on criteria 3 because the application of this ordinance to the particular property would effectively prohibit unreasonably strict utilization of the property. I think we've heard ample evidence to the contrary. There's community people have been living back there for some time, generationally, even back to the Civil War, perhaps. That's a long time. And that property, I've personally been to it, is heavily used for agricultural purposes. They have sprayers, tractors, all types of farm equipment and implements that go in and out of there. I've seen large trucks myself go in and out of there. Certainly a fire truck could get down there if one needed. I don't see how it meets criteria 3. I understand future use and zoning, but at present, I don't think they meet criteria 3, and that's my motion.
Do I have a second?
Second.
All right, we have a second by Mr. Jordan. Okay. Any discussion? All right, let's bring it to the vote. All those in favor to deny case BZA 0922-00614, please indicate by saying aye and raising your right hand.
Aye.
No, So you have 1, 2, 3, 4. My hand is up. All those that are in favor, please indicate by saying aye. Oppose the motion. 2. It carries. Okay. So unfortunately, sir, your application has been denied. You will get information from staff within 10 days letting you know the next steps in the application. Okay? And at this time, I'm going to ask that we take a 10-minute but brief break and adjourn. Come back at that time.
We only have one more left.
I hope so.
Hey, Sal, how are you?
Sitting in the home sweating. Yeah, I turned my back and I was getting ready. So I was like, this is ridiculous. I'm like showered and like sweat.
Okay, let's reconvene.
Get what you need.
Next case that we have is case BZA-09-22-00165, and that will be done by Ms. Working.
The applicant, Steve Hubrich of Hubrich Contracting, Inc., and the property owner, BFP LLC, Beast Ferry Properties LLC, and South Battery Properties LLC, care of Sean R. Willis of Nelson Mullins, represented by Kate Stafford of HLA, Inc., is requesting a variance for a proposed charter school at 1435 Bees Ferry Road, which is TMS number 286000041 in the St. Andrews area of Charleston County. More specifically, the applicant is requesting to reduce the required right-of-way landscape buffer along Blue Water Way for approximately 125 linear feet within the easement, to reduce the required 10-foot type A land use buffer by 10 feet to 0 feet, and from the following requirement, in quotes, all corner developments shall have buildings located closer to the corner. The majority of the parking shall be located behind the frontmost facades of the building, end quote. The subject property is located in the industrial zoning district on the southwest corner of Bees Ferry Road and Blue Water Way. Properties across from the subject property are located in the industrial zoning district. Adjacent properties to the southwest and southeast are in the city of Charleston's jurisdiction zone SR1. The property to the northeast is located in the urban residential UR zoning district. The applicant is in the site plan review process for the proposed two-story public charter school, and that serves kindergarten through 8th grade. In addition to the school building, the site has parking for staff and visitors and 2 separate loops for parent drop-off and pickup. The subject property is a total of 13.3 acres. These are the ordinance requirements. Aerial photo. We visited the site on October 18th, 2022. Some photographs of the subject property and the Blue Water Way and easement, Bees Ferry Road, and surrounding properties. Staff found that the requests may meet 1, 2, and 7, that it may not meet 3, 4, and 6, and it meets 5. We received 3 letters of opposition that are in your packet, and then 25 letters of opposition in your supplemental packets.
the BZA's action, the board may approve with conditions, or deny the requests based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, staff recommends the following conditions. 1, prior to zoning permit approval, the applicant shall complete the site plan review process. And 2, the applicant shall provide an architectural screen wall for any vehicular staging areas, student drop-off and bus staging loops with frontage facing Blue Water Way or Bees Ferry Road. And this is the site plan, the property, and the plats. Do you have any questions?
Mr. Marchant?
Ms. Working, just a general question about the supplemental opposition, because I haven't had time to read
Okay.
the 30. I mean, we just got them.
And it is on your iPad.
Right.
Yes.
General points from all 30 of those, or
Well, in general, I think, I don't want to over summarize, but I would say people aren't necessarily opposed to the school, but they're opposed to a school that requires variances. There will be traffic. Right now, there's not a traffic light. I'm not sure if there will be, but I think the applicant's going to address that. But just the traffic, the cut-through traffic,
Okay, thank you.
and the fact that it's a school that needs variances.
Yep, thank you.
With multiple parts.
Anyone else have a question for Ms. Working? Thank you so very much for the job that you've done today. Is the applicant present? Very good, sir. Please state your name and address for the record, and please tell us why we should approve your application, sir.
Good evening. My name is Steve Hubrick with Hubrick Contracting. I live at 4321 Medical Park Drive, and that's in Durham, North Carolina. We have been working on this Carolina Voyager project for 6 years. They're currently at the St. Andrews campus. It's a CCSD charter school. What we did is when we've gone all over the county and the city trying to identify a site, and with any school, we've got to go to Office of School Facilities and meet with SCDOT. So we did a traffic impact study. Just wanted to I know that you haven't had a chance to read them, but I've read every one. Every one of them has something to do with traffic, of the existing traffic that's already having a problem on Blue Water Way trying to get onto Bees Ferry. And we, along with DOT, City of Charleston, we have agreed to put in a traffic signal because the traffic signal was already borderline at this point, but the school actually kicked it over the threshold to require a traffic signal. Originally, City of Charleston had verbally agreed to possibly participate 50% in a development agreement, but then once they looked at their budget, they decided that they didn't have anything in their budget this year to do that, so we're going to be putting in the traffic signal at our cost. So I just want to let you know that will improve that entire intersection, Blue Water Way to Bees Ferry. That traffic will then have a dedicated traffic signal with fluted poles and mast arms to meet the City of Charleston's requirement. So I wanted to mention that. As far as the criteria, I'll let Barry Whalen with HLA speak to those issues, but I just wanted to let you know that we are maintaining a buffer on the front on Bees Ferry and Blue Water Way. The 125 feet we're talking about, it was in those pictures up there. It's the easement of the power lines. When you drive by there now, there's nothing there. So we're going to maintain the buffer along Bees Ferry from our entrance all the way to the corner. And the reason we're moving the building back is because, as you see on the site plan right there, there's 5 oak trees, 3 of them live oaks. 2 of them are Bs and 2 of them are Cs. We're trying to save the live oak trees and also provide circulation for over 2,800 feet of stacking. So we have half a mile of stacking on site to get those cars off of Blue Water Way. So I just wanted to point those, I think those are important items as you consider our application. I really appreciate the opportunity to come here tonight. And I'll turn it over to Barry now so he can, I'm sorry.
We got to finish with you first.
Okay. So that's all I have to say. I wanted to turn it over to Barry to go over each criteria.
Oh, yes, sir. Do we have any questions so far?
I'll ask one, and I think you said this in your presentation, but CCSD was involved in citing the school as well?
So CCSD was, no, they didn't help us find the school because the charter school is required for 100% payment of the school. So we were required to go out and find our own site, work through the process with Office of School Facilities at the state and SCDOT, which triggered the TIA and us counting the traffic along Blue Water Way. So they've been apprised every step of the way, and we send them monthly updates on where we stand with the process, but they weren't part of the process in selecting it.
Okay.
If that makes sense.
Thanks.
Ms. Walls?
Just a quick question for you, since you're talking about the traffic and the traffic lights, because I live in that neck of the woods. Blue Waterway is one way in, one way out, and so how do you think traffic from the school, pickup traffic, buses will impact? Even though you might have a light there, what kind of impact will it have on Blue Waterway? And I know a lot of schools now, when you get there, the bus traffic is lined up, the car traffic is lined up, and it's hard to maneuver around that kind of thing. So I'm just curious, have you all thought through that?
Yeah, so that's all part of our traffic impact study that we submitted to DOT in Charleston. But basically, this is a small school. It's 414 students. It's not going to get any bigger. They don't have any school buses. So we've got half a mile of stacking, dual stacked on site, along with a dedicated right turn lane coming into the site. So it's not going to impact traffic coming in. And then traffic going out, we've got now a traffic signal that will have a dedicated left turn lane, a dedicated right turn lane coming out of the subdivision with a traffic signal. And that's where the traffic has been backing up, is because there was no traffic signal there. It's just simply on a stop sign. And you either wait 5 minutes to try to get across going left, or you got to take a right, go down to the next intersection and do a U-turn. But the traffic signal will be dedicated left turn lane right there.
You don't anticipate it ever having buses come into that school site?
And maybe an activity bus every once in a while, but it's a 414 student school that will be carpool and car traffic only.
And the carpool traffic, you don't think would be an issue?
No. Our requirement by SCDOT for a school this size is 1,500 feet of linear feet of stacking, and we have 2,825. So we've almost doubled what the requirement is from SCDOT and OSF.
Yes, sir, Mr. Jordan.
So does no buses compute into more cars?
I'm sorry?
No buses, is that compute into having more cars than you would if you had buses?
Yes, if you had buses, clearly you'd have some of the student population taken out of the carpool lane. But that, for a school of this size, 414 students with no buses, we were required to have 1,500 linear feet of stacking based on the ARMS manual, and we're providing 2,825. I'm sorry?
It would still be a lot of cars in and out?
Sure.
Thank you.
And I've got a traffic impact study here too, if anybody would want that.
Mr. Boykin?
Read the report.
Just real quickly, I was looking at your site plan. Will y'all also be covering and I drive that road all the time going to Walmart from Johns Island. I guess what I'm wondering is there room enough, or will y'all be constructing a left turn lane on Bees Ferry Road if you were, I guess, traveling east? I know you're going to put a traffic signal in. Will that include the ability for cars to move over into a left turn lane and have a light and an arrow for them to turn
on
Blue Water? Yes.
On Blue Water, taking the left onto Bees Ferry?
Well, I'm talking, if you're on Bees Ferry and you're traveling towards U.S. Highway 17 and you want to turn left buses and cars included, right now it's just a 2-lane road and there's a narrow median in the middle.
Right.
So is there enough room there to construct a left turn lane so that vehicles can pull over and get out of the way of traffic as they're waiting to turn left on the Blue Water?
I don't know if that is.
I'm just wondering if this is going to require more than just a simple traffic light. Because left turns, I mean, they're going to be dealing with, you got to have a turn arrow because they're going to be sitting there waiting for all the traffic coming the other way down Bees Ferry Road. And those cars might not be able to move and they're going to be impeding traffic coming from the Walmart direction going towards 17.
Right.
Just
And-
generally, if you go down to the next intersection, which is Main Road in Bees Ferry, there's a dedicated left turn lane there. I don't see how this intersection can work without a dedicated left turn lane, because what it's going to do is it's going to cause traffic to back down Bees Ferry Road due to the volume of traffic that's on that road.
Yeah, again, that's just completely in SCDOT and City of Charleston's hands. We can't dictate adding
I'm
lanes.
confused. You said that the city wasn't up for paying for the traffic, like y'all are going to be 100% for that, but I don't see how you don't have road construction involved in that to create that left turn lane. And is the city going to take that on, or is that something y'all are going to take on?
Mr.
No,
Boykin,
that's
Mr. Whalen may
SCDOT's
clarify
road.
this, but there is a left turn lane on that section.
There is one now?
Of Bees
Okay,
Ferry
okay, all
Road,
right.
so.
And that's a
Thank you, I'm sorry.
SCDOT road. If DOT reviews it and required something, then yes, we would be responsible.
No, sorry, Mr. Elson, I didn't realize there was one there for that one. Okay.
Yeah.
Gotcha.
Does anyone, Mr. Jordan, go ahead.
So you're taking responsibility to put the light up?
Yes.
Does that mean you're taking responsibility for future maintenance?
No.
Who would do that?
Charleston.
Thank you.
It's a City of Charleston traffic signal, and it's City of Charleston Street on Blue Waterway.
Thank you.
Anyone else? Thank you so very much for your testimony.
Thank you.
I guess you're up next. Yes, sir. Come on up. If you would, with the same protocol.
Barry Whalen at 130 Dunham Avenue, Charleston, South Carolina, 29403.
Thank you, sir.
We're helping with this project and coming up to speed. So I'm not Kat Stafford. Her husband's deployed to another state with the military. So I'm filling in and catching up as much as I can, because we actually have been working on this as a group, but I myself have been less familiar with it. So the fact that we actually came back with comments after we thought we had a cooperative arrangement coming along, that we're still questioning some parts of the criteria, is a surprise. But we know staff's working hard. They're keeping up with a lot of business. A lot of things are coming through. And so we all didn't have enough chance to share some more discovery, because we have a lot more discovery that's happened in a short period of time as well. Back to the first question, yes. The right-of-way of Bees Ferry already has the room in it to go ahead and put the left turn lane that'll be part of the traffic signal. That's going to be part of the minimum criteria they have to work with. Next part of it is most of the different questions that seem to come out of what the staff's review of those criteria items seem to deal with a couple of very specific questions, specifically that the building itself might be too large for the property, that there's questions about whether or not you can get the use. And I can go through specifically item number 3 that's in your criteria is the building size. This building is 80% of the size of the classrooms that exist with what they're doing in St. Andrews now. They have met a smaller criteria than what the public school size for buildings are to begin with. So that is a reduction of what it otherwise would be. The traffic question that you had, ma'am, the fact is they have to have all the circulation lanes inside the site, because the goal is to suck the traffic off the road and get it into the site and circulate around in the site, not be the so many problematic situations that you see out on a public road where it's not really set up to accommodate multiple lanes of traffic going into a school site. In fact, this is the school site itself is to absorb it. And that's why it has to have a certain amount of the circulation on the site that is questioning whether or not is that too much activity on the site. Well, in order to make things work even better, if you see this, first of all, this red outline, that's the only place on the site that can be developed, because we're staying out of the trees, the grand trees that are up here on Bees Ferry. No grand tree variances, none, 0. Okay, just in case we wondered. And then you go through here, you've got all these wetlands that are being preserved, and there's already restrictive covenants set up on the wetlands for buffers. So you only have 4.94 acres of site that you can work with to begin with. Out of that 4.94, that's inside the red there. Now, if you look in a little closer, what you really see is there's most of these circulation lanes going around. But you see this blue color? That blue color is that because there's a condition that staff doesn't know. There's a shallow groundwater condition out on the site that prevents from the ability to have deep stormwater detention ponds. So this site actually has 82% of the drainage that's going to be needed to supply for the site, together with all the resiliency efforts that we're going to have as part of that stormwater solution, are all going to be underground at great expense to the project, but with the ability for making sure that it causes no drainage issues in the area. And that's part of what the intensity of utilization on the property is. They have to end up having drainage that's under these circulation lanes. That means we get all the traffic off of Blue Water and off of Bees Ferry into the site. It's a very compact site concept. And I think with a little more time and exchange with the staff, we probably would have arrived at a little bit more of the sharing of some of this information that would be helpful. The next part of some of the rest of the building size, as I said, is reduced from where they're at now. They're not increasing. They're not trying to add students. They're trying to take a successful program and put it into place. Number 4, the public use of the property itself. It's zoned industrial. So with the industrial zoning on the site, you have the ability to go ahead and obviously develop much more noxious or intensive uses on the site than this school. This site school is exactly the kind of thing that you want to have in an area where you have residential to begin with. And even though it's a starting population that's at another location, it's a feeder school opportunity. It's got kindergarten. You know, the kids will evolve through. Eventually, the sidewalks that are being accommodated and arranged will be having that residential area be able to use this as their neighborhood school to the degree they want that to happen and be a part of it. So it really is an appropriate use. Industrial allows for 55-foot height. This is a school that's only 32-foot height. So you think of that in terms of the scale. It's the right scale for an area like that versus the intensity of industrial. You have any number of the other things, the variances. We can't put any landscape buffering here in the power easement. It's not required. Now these days, Dominion, they would talk to about this. We went through and petitioned if we could. They said that they now end up spraying their easements because it's just faster for them to do it. Weed killer. So we could go ahead and meet the requirements, plant the plants, and have them meet their criteria, not being too tall, still enough to have some buffering, but they're going to kill them. And so we're trying to figure out how to make sure that everybody comes to speed on how the different infrastructure maintainers are working with it. That's all we're asking to do. We can't put buffering there. We stayed off the corner here. The overall property is as tightly used as possible.
Okay, thank you. Let me see if anyone on this board has a question for you because your time has expired. Does anyone have a question? Miss Smalls, I'm gonna let her go. She hadn't had a chance.
Ladies first, always.
Ladies first. There you go. Miss Smalls.
Will you tell us how you meet requirement number 3? Because here the staff has listed that the application of this ordinance to the subject property may not unreasonably restrict the utilization of the property because there's approximately 5 billable acres, and that a smaller developed project with less vehicular traffic usage, planting buffer, vegetation, that kind of thing. So can you tell us how you think this project meets criteria number 3?
The site is utilizing the center of this property, effectively taking drainage and putting parking in the same place that normally have to be separated. You have what is seen as being unreasonably restricting the utilization of the property. If you can't utilize this portion, the 5 acres, in this manner, the rest of this total 13 acres ends up being something that can't be utilized unless you use the center core of the property. So that's why we're trying to suggest what happens here and where it's located. We're trying to get traffic off of the roads, get it into the site, and utilize the site for this particular use, school use, that's much less intensive than industrial use would be. It's just utilizing the site to the The fact that there's been a coordination together with this traffic signal, the existing traffic problem that exists now out there, is something that this brings a solution to it for the use that makes sense. And
Does the owner own all 13 acres of that whole site?
this is a total of
But-
13.3 acres.
They decided to build just in that one corner. It's okay, gotcha.
Live oaks are up here that we're avoiding, so that's why we tried to make sure you understood how we're taking the use into the center of the site itself, but that provides buffering, and I think it's a more aesthetic solution anyways for the community.
Did you have a question, Mr. Marchant?
Yes. I hope I heard this right. You said Dominion would be coming by spraying the vegetation?
I'm sorry, say again?
It would be coming by spraying the vegetation?
I'm sorry, but hearing
The
problem.
vegetation, did I hear you say Dominion will come by spraying it?
Yeah, that's just here.
Okay, so my question is, with all that water that you're gonna have there, where is the runoff gonna go to from the spray?
The runoff from the building goes,
Runoff from the spraying, the chemicals?
oh, this is Dominion, we're being told that's what Dominion does for weed control now.
I'm sure everywhere, but I was just curious, with all that water that you're gonna have there, where would it gonna stay there? Is it gonna drain off somewhere?
Oh, yeah, with it outfalls into the drainage away from the power easement. The power easement can't be utilized for stormwater detention.
So it won't go in no neighborhoods or nothing?
No, it goes into these wetlands.
Mr. Nelson?
As part of staff's, if we were to approve this request, staff has a special condition in here that says the applicant shall provide an architectural screen wall for any vehicular staging area with frontage facing Blue Water Way or Beast Ferry Road. Do you guys have a particular issue with that requirement? Would you be okay with it?
I would be okay with it, I just don't know what that means. You know, this all along Beach Ferry is gonna be heavily buffered.
Okay.
Live oaks are gonna stay, this is all gonna stay, this buffer across. So I guess we don't have a definition, but I wouldn't have a problem with when it just says architectural wall. We got that comment Friday.
Okay, we'll get some clarification from staff when we get to that point.
That was part of the idea. This has all come fast. We'd like to say, if it's away from the street, is it better to have a living wall? Is it better as a fence? Some combination of landscaping together with it. We just thought we'd arrive at that conversation if we can get there.
Okay.
But to answer your question, no, we would accommodate.
Okay.
Does anyone else have a question? Mr. Marchant?
Mr. Whalen, can you just show on the, excuse me, on the colored site plan, where is the zero buffer? Because just there, that's the
It's
only,
the only place.
so that's the only request for variance in a place where it's
Right.
going to be sprayed and killed anyway.
Yeah.
Is that my understanding?
And there's a suggestion that because we don't have the building up here in the corner where the grand trees are and taking those out, that it's not bringing the building to the corner. And we're saying that that's what you would want us to not put the building at the corner. You don't want us to take out the grand trees.
So,
To answer your question, though, we also, the property line here is what's also zero.
Right.
So there's already an existing tree buffer here. That
On the other side.
That we go share a property line with the assisted living facility. And there's approximately like a 50 to 100-foot buffer there now. Dominion said we could put a fence up there if that would meet the desire. We just didn't know what that would do. But if that met the desire, we'd put a fence up.
So if you were to plant the buffer, the 10-foot buffer to the, is that south, planned south? I mean, I guess that's real south. Yeah, true south. And the area to the east, they're going to kill it anyway, right? So you could go do it and meet the requirement of Zeldar, and not even ask for the variance, is what you're saying. Is that fair?
Mr. Marchant?
Yes.
The ordinance requires that 10-foot buffer to be interior to the easement, not on the property line.
I understand. Okay, thank you. That's helpful. Thank you. Perfect.
Styles going to keep you in check now, so you are Styles.
Awesome. Thank you.
So it wouldn't die if it was on their own property. Yeah.
Assuming their spray stays in place.
Anyone else?
Just sort of a comment, and I appreciate that. I guess the question is, what are we buffering from, right? In that case, we're buffering from an easement, a utility easement, not from people or neighborhoods or anything like that.
Well, it's to supplement buffering from the adjacent property.
Correct.
But locating it in a place where we know it will be maintained.
Right. But if I understand correctly, we have a pretty substantial landscape buffer to the south of the property. I know it's not theirs. Then we have a utility easement, and the variance is for the 10 feet between the easement and the
school.
and the existing. Yeah. Okay. Thank you. I'm looking for spirit of buffer.
Thank you, gentlemen. Thank you. Do we have anyone to speak in favor of this application? Anyone else to speak? Oh, yes, I see your hand there. Please come forward. Please state your name and address for the record and tell us why we should approve this application.
Sure. My name is Jamie Innes. I live at 1722 Batten Drive here in Charleston. I am a resident of Bolton's Landing. My son has been at Voyager from kindergarten to 5th grade now. My family's over there. And we've been a proud Voyager family since he's started. I believe the majority of the residential comments were possibly due to the lack of information that was provided initially when one of our neighbors posted the link to the zoning packet. The case packet was not available until I saw the image last night for the site plan. So I shared that with our neighborhood Facebook group last night so they would understand how the 2-car loop would work and the traffic would move into the site instead of on Blue Water Way. I think there is a large assumption by our neighbors that there's going to be traffic on Blue Water Way from one end to the other. And of course, for every one of us, that would be a huge concern. But being currently on Wapu Road, we run carpool very efficiently by Mr. Cable. He's wonderful. And we do a 2-car loop lineup currently on Wapu Road. We line up in the back and it moves forward pretty quickly. I think within 10, 15 minutes, we're in and out with our kids. So we've been very good neighbors. We share the building with Paddington Academy. We ensure that logistically we maintain very fruitful relationships with our neighbors. Paddington's Academy is a special needs school. They have lots of buses and wheelchairs that have to come in and park a certain way. So we are very sensitive to their needs. We're also sensitive to the day school across the street to ensure when our school gets out early that our parents do not park in their initial parking space because it is very limited, so that they can get their kids in and out and their parents can come on site as well. So Voyager as a whole, I think, would be a tremendous value to the Bolton's Landing community. I've been a resident there since 2010. We've seen storage units being built, gas stations. We now have a Starbucks, which is great. We can golf cart to the Starbucks from our neighborhood. But we've also seen the negative. We've seen the multifamily housing that's been built on every corner. I mean, we have, I think, 3 going up on Glen McConnell. There's 3 more that are going down by the Publix on Savannah Highway. I'm more concerned about getting off Blue Water Way onto Bees Ferry Road and Glen McConnell. I work from home full time, but my husband does drive to MUSC every day. And with the multifamily housing that's being built, that's 2 cars per unit. That's a lot of vehicles on the road. So at some point, we have more concern about Bees Ferry and Glen McConnell being gridlocked with all the traffic. But I think the site plan was developed very well this go-round, and we have attempted, I think, 4 times to build in West Ashley. So I beg and plead that you guys approve the variances so we can build our school. We have a very wonderful school with a dedicated staff that is just like family. So thank you.
Thank you. Hold one moment, please.
Yes, sir.
Do we have anyone that has a question for her? Thank you so very much for your testimony.
Thank you.
Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor? Do we have anyone to speak in opposition? I saw this young lady's hand here. Yes, ma'am. If you would, please come forward, state your name and address, and tell us why we should deny this application. Oh, no, Oh, you speak in favor? Okay, I'm sorry. Maybe I went too fast. Okay.
My name is Lisa Flowers, and I live at 1554 Seabago Drive. And my son Lucas also attends Carolina Voyager. It is a wonderful school. I think that Jamie did a wonderful job of letting you know how passionate we are as Voyagers about our school. But I am also passionate about the community that I live in. And I do think that this would be a great addition to the community because it would give the community an additional option to just the regular public school, and it would be in close proximity to our houses. And to speak on the traffic pattern and everything that we go through currently at the WAPU school, it is very fluid, as Jamie said, and I also travel with my son there from Bolton's Landing and make a commute to Mount Pleasant every single day. And I can tell you that I probably spend about 5 minutes trying to get out of either side of the community. And so therefore, a school with 413 students, I don't think is necessarily going to move the mark, especially if there is going to be a traffic light that is going to be put in place with a left-hand turning lane off of Bees Ferry into Glen McConnell, which already exists, and then all of the traffic justification with the light that is going to be paid for by the school. So I just think that it would be a great opportunity to have something positive come into our neighborhood instead of additional industrial building. And I thank you for listening to all of our comments and listening to the builders talk about the logistics and how efficient the school is actually going to be.
Thank you. If you hold on one moment, please.
Yes.
Thank you. Do we have anyone that has a question? Any board members? Thank you so very much for your testimony
You're
today.
welcome.
I kind of moved kind of quickly there. Do we have anyone else that want to speak in favor of this application? Okay. Do we have anyone to speak in opposition? Okay. I'm going to let her go first, okay? Please state your name and address for the case and tell us why we should deny this case, please, ma'am.
Hi, good evening. My name is Amanda Thomas. My address is 1501 Boom Bang Lane in, I know it's an awesome name, right?
1501
Boom Bang Lane. There's only two of us.
Okay.
It's pretty awesome.
Okay.
And I live in Bolton's Landing as well. And I will be honest, following up with Jamie and Lisa's comments, I think it's more of a concern that we were at the last minute thrown a lot of this information, and the concerns of the residents probably could be answered by the developers if we had time to sit down and talk with them. And I think that there's a lot of misconceptions that are happening. So that being said, the Facebook page blew up in the past 24 hours. So I'm just going to ask a couple of questions and concerns and express my pure personal question that came up with the variance question, which is really why this is happening this evening. With the statement of the variance of the buffer itself, it sounds like that they're maintaining the front and the side, and it's only that one little spot. Are they allowed, once this variance is approved, if it were to be approved, are they allowed to go back and then change removing of the trees and the bushes if they decide to change their mind, I guess, because they've already had the variance approved? And that is a lack of knowledge on my part, and you might be able to clear that up for me. With regards to the community itself, there's a huge concern, and has been for the past 5 years that I've lived there, that Blue Water is a cut through from 17 to Bees Ferry. Yes, we have the left turn lane, but it is literally like playing Frogger trying to get in and out of our community. We've been begging for a light for years. So I know that there's a lot of excitement with the idea of a light. There's also a lot of concern that the 17 is going to be the cut through. There is no plan as of right now for a left turn into the school, which could really back up traffic, people trying to get out during school hours if you're waiting behind a left turn lane. And so that is a huge concern. Another concern, is the fact that during special events or what have you, yes, they have enough parking for most people, but what about runover? Will that end up on Blue Water Way as well? And then the last part that was a concern, they did address the buses issue. The last part, that was a concern was, the fact that the traffic light is being built by them, which is awesome. What happens when it breaks down? Is the city okay with, hey, you built it, that's fine, but we're not paying for any repairs on it or what have you? So I think there's a concern there with making sure that all of the stuff that had to be built around it, like you guys brought up, the turn lanes and what have you, making sure that that bill gets footed as well.
Okay, good questions. Does anyone on the board have a question for her? I know you left some questions to be answered, but we'll
Right.
try to get those questions answered for you.
And like I said, I'm not necessarily in favor or not in favor. There was just a lot of unknowns.
Rightly so. Thank you so very
Thank
much
you
for
for
your
your time.
testimony. We'll get a chance. Do we have anyone else to speak in opposition? I saw your hand, sir. Okay.
Bart King, 1475 Sebago Drive in Bolton's Landing.
That's King?
Yes, sir. I didn't know if you could actually pull up the map that you had earlier of the property overlay. Yeah, that's it. Okay. What you're looking at is the entrance to our neighborhood from Bees Ferry Road and onto Blue Water Way. I think the point of contention with the neighborhood on this property being developed here is not that it's a school going in. It's just that we're trying to fit 10 pounds of rice into a 5-pound bag every day, and now you're adding a school. If you noticed right there in the front of the property where they have their entrance, which is right there on the Blue Water Way, directly across from this, which is on another place, directly across is a new unit that just got approved by county council for townhomes. And that entrance is directly across from it as well. So there's two entrances that will be coming across onto Bees Ferry at the same point. So that will be a point of contention for us. Also, Mr. Boykin had asked about the left turn lane off Bees Ferry Road. There is a left turn lane off Bees Ferry Road. The problem is that it only holds 5 cars. All right, and now we're wanting to shuffle in all this traffic, even with a red light, at 2 different times of the day. Something needs to be addressed in that form there. It's whether you push it back, it's going to stop traffic on Bees Ferry Road. Once again, I'm not against these schools. We got some great neighbors here, sends their kids there. This gentleman says he wants it to be a community school. I would take pride in that myself, especially if he gave our HOA priority as members. But we need to take those 2 points of contention in because it's going to cause extreme distress to the residents that are there, that we are having to face this every day. We've already had to get speed humps put through the neighborhood due to it being a cut through. The police have had to come out and put speed limit signs, the constant that measure, trying to slow traffic calming measures is what they call them. But there really needs to be a point of emphasis from this developer in regards to not just a red light, but whether it's better egress with wider turn lanes, addressing Bees Ferry Road with drawing that out. 5 cars ain't going to cut it. It's not going to work. But that is the biggest point of contention that I and the majority of the neighborhood are feeling right now.
Okay, hold tight. Do we have any questions?
Just a quick one.
I'm going to let him go first.
I want to make one comment, and this isn't necessarily a question for you, but one thing that the community should realize is that the property is zoned industrial, which is and correct me if I'm wrong, that is the most intensive use that we have in Charleston County for a zone property. And so there are a lot of uses that this property is zoned for that could be more intensive than the school itself. So I'm very proud and happy to hear that the developer is willing to do a myriad of things, including installing a stoplight at their own expense in order to alleviate a lot of the community's concerns. So I would encourage you to work with the city of Charleston going forward to address turning lane issues and that sort of stuff. That's a little bit beyond our scope tonight.
Okay. Mr. King, I was going to say, I absolutely agree. That was kind of where I was going to get to. I forgot there was a turn lane there to begin with, but the same situation on Main Road approaching Highway 17 from Johns Island, all those folks that are trying to turn left and go south on 17, that backs up. There's no more room for the cars. Then the people behind are holding up that center lane that takes you across, and it backs all the way up because there's no way to get around it. And so the same thing with that inside lane on Bees Ferry Road that people are trying to just get straight down the road. So I'm not sure how the coordination would work, but I do think the city of Charleston would have to be involved with it. But you're right, that if we're going to have school and students trying to get in there, there's no way 5 cars is going to get it done with the cycling of the light. People will be stuck out there holding up a whole lane to try to turn. So there is room there, though. They can extend that left turn lane by taking out part of that center whatever.
Yes.
Okay.
Yes. Okay. And this is a unique situation to us because this is a charter school. This is not a public school where we're going to have public input. Once again, the gentleman, Mr. Nelson, had said, it's in zoned industrial. Could have been anything up there. You've already put apartments on both ends of us. We're gambling that we could get a storage building. Less traffic, but we're in this pickle, we would hope that, during this, what you're about to approve here has some form of weight onto what they're requesting to give us a little bit of relief because, as you know, traffic is something else already.
I'll run it one quick thing, and just to bring us back to center on this, all we're here to do today is approve a variance for a landscape buffer or whatever, not whether a school does or doesn't go there and the traffic impacts. That's way above us or beyond us. Okay.
Thank you so very much for your testimony. We had one more.
Good evening.
Hello.
My name is Danny Abad. I live on 1454 Seabago Drive in Bolton's Landing, right down the road from Mr. King. Firstly, I would just like to say thank you for wanting to add a charter school and for supporting education here in the state. It is definitely meaningful for everyone in the neighborhood. Like everyone mentioned previously, the neighborhood is just concerned based on the traffic. I know you just mentioned that's kind of above this level. I think that a lot of the neighborhood wasn't aware what level to actually approach this at. So I think this was the first opportunity. So that's why people kind of jumped on it. So I'm actually going to read a little bit. I'm not going to be able to remember everything. Because there were people that were mentioned in the Facebook group earlier that did have some concerns, so I wanted to share them as well. Firstly, I would like to say the intersection of 17 South and Main Road, sir, which you mentioned, is one of the most congested intersections in the entire county. So that's going to be amplified by the rush hour. So rush hour is obviously the 8-hour workday, and then on top of that, you got your schools that will be coming through. So Main Road is one of the 2 entrances into Johns Island, and with the second entrance being pretty far away, roughly 5 miles downtown. So this is a subsequent intersection following 17 South and Blue Water Way, and the entrance to the Bolton's Landing area. So similar to Johns Island, Bolton's Landing only has 2 entrances. So that's the 17 South entrance and the Blue Water, the Bees Ferry entrance, excuse me. So with that being said, a lot of the drivers in the county like to use it as a cut through from 17 South over to Bees Ferry. Unfortunately, because of that fact, a lot of drivers speed through it, and that's why we had the installation of the speed bumps. I think that with the addition of the school, we may see even a higher influx of traffic, especially during that time of congestion. And unfortunately, there are no traffic lights at either entrance. So that, again, could cause more traffic. Sir, I'm sure you probably see it all the time living in Johns Island. So we've seen an influx of accidents and, unfortunately, an influx of injuries due to those accidents. So as John Island grows and as West Ashley grows, these will continue to grow as well. With the building of a new housing complex right across the street of Blue Water Way, we're going to see even more congestion in that area. And then same thing from the entrance into Blue Water from Bees Ferry. That 5-car is not going to be enough length. So, like you said, sir, that's going to pull back into Bees Ferry toward West Ashley Circle. So I would just like to say, if you could please just take into consideration the 5-car length. You mentioned the chemical, sir. There is a senior home right behind where the school is going to be built. So in regards to those chemicals, we're not really sure where those chemicals are going to go. I know you mentioned it might go into the water lands, the wetlands. Is that where you said? No, that's where the drainage will go. The drainage. Okay, sorry. Thank you. And then, so the Facebook group that was mentioned earlier, there was a poll. There was 80%. Okay, sorry. Thank you for your time.
Thank you.
If you have any questions.
Do we have anyone else to have a question of this young man? Thank you so very much.
Thank you all for your time. And thank you again.
Do we have anyone else to speak in opposition? Do we have anyone else to speak in opposition? Very good. So you have the right of rebuttal, limited to 2 minutes.
My name is Nicole Stott. I'm an attorney with Nexon Pruitt. I've been asked on behalf of the applicant to do the rebuttal.
Okay.
So I'm with these guys. I think the most important thing is what we did not hear tonight in regards to the opposition. I'll address that first. We heard a bunch of opposition to the traffic, as Mr. Boykin appropriately pointed out, is not a topic for consideration by the BZA with regard to this variance request. We did not hear any opposition to the variances that we've actually requested. So I think that's important to note. Is it possible to get the site plan back up? Going back to the variance request itself, this is a very unique property in that more than half of it is taken up by wetlands. And then another big portion is taken up by trees that this county and most people want to protect. Because of those conditions, any project that gets developed on this site is going to have to be pushed back up against that easement, out of the corner and up against Blue Water Way. And I think that those two factors alone, it is my submission to this board, that those two factors alone justify these variance requests. Yes, we could maybe try to shuffle the property up closer to Bees Ferry and ask for a variance request to cut down a tree in order to get that 10-foot easement along the back. But as Mr. Marchant said, is that easement really serve a purpose other than, and I may be putting words into your mouth and I apologize for that, but in my words, does that easement really serve a purpose when we've already got so much of a buffer there between the property line and the adjacent property? Is it just a requirement so that we can check off a box? Therefore, I submit that the variance test has been met, and I've requested the board approve the application.
Thank you so very much for your testimony. Do we have any questions for her? Thank you so very much.
Thank you very much for your time. I appreciate it.
Okay, this case is now closed to the public. Board members, do we have any additional questions for staff? Mr. Nelson?
The architectural screening wall, can you provide a little more information about that and whether or not with the plans that you've seen that that's a necessary special condition for this?
Yeah, so the architectural screening wall is something that we often will ask for when there is loading and parking that has the potential of throwing headlights out into a roadway. And as you can see in this site plan, with the fact that the loop does bound the right-of-ways, one of which has a buffer that's only 15 feet deep, the architectural wall that we have in our ordinance, we request that it's 30 inches high, tied in with the architectural design of the site, just to, keep that additional low screen at that headlight level off of the roadways. And so it's something we would normally ask for if we had those loading areas fronting a roadway.
Okay, thank you.
Mr. Marchant?
Ms. Stiles, can you expound on that a little bit? Because I understand what you're saying. The question is where. Would it be at the turns near Bees Ferry, where the corner of Bees Ferry and Blue Water? You kind of have that loop road where the two turns are, right? And to me, that's where the lights would point into the right of way of either Bees Ferry or maybe Blue Water. But you're not suggesting all the way around, are you?
No, we would be talking only where it fronts the right of way, and so it would be the short part of the upper L and the long part in front of the building.
So that whole long part, even though the cars are really traveling north.
Correct.
Okay. Because the headlights are really going into Bees Ferry. They'll never get to Blue Water, right?
Headlights are our main concern. Again, it's that architectural feature designing the loop into the overall site.
Okay. That's said a little differently, which I understand. Thank you.
Any more questions, ladies and gentlemen? Okay. All right, folks. I'd like to entertain a motion to either approve or deny this particular case. Do we have anyone?
All right, I will, in the matter of BZA 0922-00615, I'll make a motion that we approve the variance request. In doing so, I find that it meets all 7 of the criteria required for the variance. There are extraordinary and exceptional conditions pertaining to this particular piece of property. That these conditions do not generally apply to other properties in the vicinity. And I'll add to this as somebody who's dealt with wetland permit applications and NEPA documents where you have to go through thorough alternatives analysis and look at alternative sites and vet many different properties before you can ever get to the actual project you want to construct. It's a shame that our process doesn't really take that into account. And so I'm sympathetic to the applicant and their desire to find a piece of property that will work for them. Criterion 3, because of these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. Again, the applicant has done a very good job of using the space that is available on this property, so I find that it meets that criterion. Criterion 4, the application of the variance will not be of substantial detriment to the adjacent property or to the public good. This was probably the criteria that I was stuck on before. We heard the presentation, and simply the applicant's willingness to install a stoplight at the intersection of Bees Ferry Road and Blue Water Way shows that their desire to take care of the neighborhood in construction of this school. Criterion 5, the BZA will not grant a variance, the effect of which will not allow the establishment of a use not otherwise permitted in the zoning district. We certainly meet that criterion. Criterion 6, the need for the variance is not the result of the applicant's own action. I'm taking into consideration the constraints that exist on this particular piece of property would put us in compliance with Criterion 6. And Criterion 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. In making this motion, I would add both of the staff's recommendations that prior to zoning permit approval, the applicant shall complete the site plan review process, and 2, the applicant shall provide an architectural screen wall for any vehicular staging area with frontage facing Blue Water Way or Bees Ferry Road. I would ask the staff to be flexible in working with the applicant for adhering to that particular condition. That is my motion.
Second.
Okay, we have a motion that has been properly moved and second. Any discussion? All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous and it carries. Thank you so very much. Within 10 days, you will get information from staff letting you know the next steps in the process. And congratulations and good night. Yes, sir.
Just a comment, maybe a question for staff. Oftentimes this is the place where
You guys would hold it down, please. We're still in chambers at this time. If you're going to have a discussion, please have it outside of this chamber.
oftentimes this is the forum where neighborhood and public debate happens, which really, it shouldn't happen here. It should happen before it gets in here. And I bet we spend a lot of time in here sort of educating they educate each other. And I just wonder from a procedural standpoint or a process standpoint, is there some value in thinking about the process from a county standpoint where neighborhood public meetings need to occur first, right?
Yeah,
Because
I mean, I've been thinking about that all night.
we spend
For that reason,
we
yeah.
spend an inordinate amount of time dealing with things that can be clarified with a drawing, at an Arby's. So just something to think about because
It's something we encourage people to do, but we can't. I don't know at this time we can require, but we can continue to encourage because it's just going to make half of these be deferred because there's not enough information. I don't think you were here for the Lofton Mine site, but I think everyone was here for that one. Like that would have been a good example. They did not meet with CCSD. They did not meet with anyone on Lofton Road. And I don't think they're still going to meet with them. And you guys, so it's like I can tell them to do that, but it's like they're missing that opportunity to do that with them outside of this meeting.
I agree with you. It's hard. You can't require it. I get it. But just some forceful encouragement or empowerment would be great.
Well, I will point out that there are times when you do meet with the adjacent property owners, they just simply don't agree with what you're proposing to do, and they use this as a forum to argue otherwise.
Mr. Marchant, one other thing I'll throw out there, and we're running into it all the time, we're here only tonight to whether to grant or deny a variance for a buffer issue. Not whether a school went there, and they have valid concerns about the turn lanes and all those things. And but the problem is that's not in our world. That's Charleston County and City of Charleston that will have to fund those improvements and all that kind of stuff. But we get kind of caught up,
And I understand that, but you heard every opposition come up and say, now that I've learned this, I really am not.
Facebook would really let up.
Yeah. Mark Zuckerberg should not be the public.
They could have, I sent those 25 letters to the applicant on Friday. They could have called a meeting on Saturday.
Sure.
Right.
Right. But
anyway.
I agree. We'll work on that more, just as staff, just encouraging. And especially these ones that were deferred by you, like if they're not going to do anything in the meantime, besides just change their plan, but not like coordinate with the neighborhood. So for December, we have 1 old business and 7 new business cases. So for a total of 8. The 1 old business is the Marginal Road car. So remember there were 3 variances and 1 was denied about the building placement and then the other 2 were deferred. So we're down to just 1 variance now, and it went from 8 trees to 4 trees.
The car dealership?
Yes.
That'll be a full house.
Yeah, so that's
from what
that
I've
first
been
one. 2 short-term rentals. And then the last 2 are for Latson Elementary School. So I don't know.
Latson Elementary School?
Yeah, off of Latson Road. So I don't know what you guys think. Tonight we started at 5 and it's 8:20. If you want to try to start a little earlier with knowing there's 8 cases versus 5, like we had tonight.
I'd suggest 4 because I think the Marginal Road thing, I've been paying attention to social media and everything as far as the activity of all those folks are still very concerned about that issue. So I think we could have a lot of people to speak here.
You gonna be here?
I will be here.
I just need to make sure we have at least 5 that can be here.
I'll be here.
That's on the 5th?
Yes.
Okay, ladies. Anything else, Ms. Working?
We do have more, sorry. It won't be. So just a reminder about training. This would only apply really to, the people here would only apply to Mr. Boykin and Ms. Smalls. Just a reminder, if you want to get your 3 hours done, we're having it here on November 14th.
I will be here.
Okay. Or, Ms. Smalls, if you'd like to do it on your own, that's fine too. But that's an opportunity. And then I'll send a reminder to Woodall and Freeman who are absent tonight. Jordan, you have until next July, so you're good.
Jenny, we're going to do it in the chambers or we're going to do it in the little room over here?
It's going to be here.
Okay.
In here.
Okay.
Yeah.
All
And lastly, we need to go back and talk about the 4, if we're going to do 4, but also that now vote on the 2023 schedule. So what you want to do first? And then we'll be done.
Okay. So I think I'd like to make a motion that we have this December meeting at 4 o'clock to start early because of the volume. I closed my iPad. I don't know what the code is.
4 o'clock.
And then the, that's not it.
There's a second for that.
Okay, yep. So the agenda for next year. Wow.
We're sticking with the Monday, and then the shaded ones, the 4 dates, are the second Monday of the month.
You know, I never do have a problem with anything. I always try to plan accordingly, but we have other souls here we have to consider.
Yeah.
I will be here. Board members?
I'm not going to say anything because I won't be here next year. So.
I would motion to approve the schedule as
Yeah.
presented by staff.
Does anybody have? Okay, so right now we have a motion to approve the schedule as is submitted. And all those in favor? Aye. It is, anybody opposed? It's unanimous, so let's
Okay.
move forward with that one.
Unanimous for the schedule, and then there was a motion for 4 o'clock. Was there a second for December?
I'll second it.
Okay.
Second?
Yep.
Okay.
Thank you.
So.
That's it. All right. Well, ladies and gentlemen, I thank you again, and I'd like to wish Mr. Borkin the best of luck.
All in favor, say aye.
You vote on it?
Yeah, well, let me say, yeah.
Everyone's tired.
You ready to go home?
It's actually really, what, 10:30? 9:30? Okay.
Have a good night, gentlemen and ladies.